Last shot for any attorneys wanting CLEs, you need to sign in before we get started, if anybody slipped in since I said that last. And we're going to get started. Liz, are you okay? You need something? You're good? Okay. I understand there's still some people on the road. The storm has delayed us a little bit today, but we're going to get started. This session particularly is being videotaped. Or videotaped, yeah, listen to me, or filmed, I'll say that, to completely date myself, but we're going to do this one for posterity, so we're going to get this one started. Welcome and thank you for coming. A couple of administrative things. My name is Cray Rankamp. I'm the Vice President of Conference Services or Affairs or something like that for APA. And I want to thank very much the speakers that we have here this morning. This was a big ask to get a group of people on the dais with the degree of experience, expertise, and reputation that we have here this morning. You will find out who it is I'm thanking in a minute. Professor Trout will be introducing them. But I just wanted to personally thank them all for answering the call, both literally when I called you and the call to service to be here this morning. And just thank you very much. I very much appreciate it. A reminder, turn your cell phones off, please. And yes, I was crazy enough to set up a 3-hour and 15-minute session. No one will be surprised if you need to go to the hallway at some point. Please do it when the speakers are changing. We'll be doing that frequently enough. The reason for doing that is I wanted to make sure we had these people on the panel together for a discussion once the presentations were over. And if we whack this thing up into 1.5 or 2-hour pieces, you'd wind up with 3 at a time and not have the cross discussion that I think will be valuable. So I apologize for a long session, but I think the format of it will ultimately be its own reward. For AICP, we are pre-approved for 3.25 credits. When you go on the website to seek your credits, you'll see that we're only approved for 1.5 hours for legal. It's not my fault. I don't make the rules. I just laugh at them. The only way they do legal is in 1.5 hour increments. So that's what you can get for the legal side, even though the entire session is approved for 3.5 or 3.25. Don't call me. It's not my fault. CLE sign-ins we did. All right. Administration out of the way. As the person that set it up, I get to steal the mic for a couple of minutes before I have to run off and do other sorts of things and turn it over to Professor Trout. But I wanted to explain to you why this session exists. It essentially sprung out of a sense of rage that I started to feel a couple of months ago in reading press accounts of the last legislative session. And it wasn't so much what the legislature was doing, it was what the press was describing this issue as. It was a very clear, in their minds, left-right argument with a governor, Republican, right being against it, the Democratic legislature on the left being for it, and it was something as easy as affordable health care or welfare reform. As complicated as those are, they're simple. You line up the left and the right and you go at it. But how does that describe that the Builders Association for decades has been an ardent supporter of the doctrine, that radical left-wing organization? Or why big city mayors occasionally defect and ask out loud, impolitely and awkwardly, why do we have this policy that's facilitating my minority middle class moving out of the city? Maybe I'm not for this. Or the mayor of Perth Amboy during the transition, Christie's first transition, who asked repeatedly, why am I being required to do inclusionary housing in the one redevelopment project we have? When were we guilty of exclusionary zoning? So this is obviously not left-right. At the local level, does it really matter in suburban New Jersey between Republican and Democratic parties which one is more anti-new school children? I mean, party labels really aren't telling you who's on which side of this particular issue, no matter how much the newspaper wants to try and simplify it. And worse yet, the good reporters who wanted to go deeper and tell us what this story was all about added up the amount of affordable housing being produced and argued whether that number was large and was worth all of the angst that we went through to create it, as if that was the only metric that mattered. And frankly, for those of us that go back far enough, we didn't even know we were producing essentially a new public housing program in the suburbs when the Mount Laurel 2 decision came down. We didn't know until 1993 when COAH decided that this was going to be a cumulative system, and when you lost a unit, you had to replace it, that in fact we were creating a permanent housing stock. Maybe a good thing that we moved in that way, I'm not debating that, but to use that as the metric for what we were trying to do for the 20 years before 1993, when we didn't even know we were doing it, seems a bit odd, and begins to convey why I think this is a much more complicated issue. And that's precisely why I wanted to have this session. We as planners and planning lawyers and associated professionals need to understand, have the language and tools that I think will be imparted this morning through the session and in a session this afternoon to be able to describe in full complexity to the board members and the civilians out there that we interact with what this is all about in its full richness. To put you in the right frame of mind, I want to briefly take you back on a journey to 1971. The dinosaurs had just passed, but this was a critical year. All of you who went through planning school or took the planning test know that in 1971, the first Mount Laurel trial court decision was made. But I want to take you back. In 1971, you're now 4 years before the municipal land use law is adopted in 1975. The Zoning Enabling Act at that time had one public purpose. We didn't have A through whatever letter we're up to, and that's a quick test how you can tell how old a planner is when they tell you what they think the last letter is. They keep getting added to. But there was only one, the general welfare. And the courts considered the general welfare to be whatever the townships said it was. The court case that all of this was based on, all of us probably know, 1926, village of Euclid, Ohio. The apartment house is a mere parasite, very near to being a nuisance. A suburban municipality could exclude multifamily because the multifamily was itself a parasite and a nuisance to single-family neighborhoods. In 1952, we had Lions Head Lake in New Jersey, large lot zoning, minimum house sizes, all kinds of gold standards in improvements, and the court basically said there's no such thing as a regional interest for housing. That's the world that you occupy in 1971. So put aside what you know and heard about Mount Laurel in 1971. I want to tell you what else was happening in that year. In 1971, Mr. Surik in Upper Providence Township, Pennsylvania, wanted to do multifamily housing in that single-family community. And the Oakwood Development Corporation in Madison, New Jersey, you can be forgiven not knowing where that is, it's now known as Old Bridge, wanted to do the same thing in a community that was exclusively single family. It was also the year that the Allen Dean Corporation on the lands that's now the Hills in Bedminster, and the Round Valley Corporation in Clinton Township on what is now the Beaverbrook PUD, hired a land planning firm in Philadelphia to start laying out those communities. And the reason why that land was attractive to those communities for a mixed-use, multifamily friendly PUD was that both of those municipalities had attracted major corporate headquarters. Great employment coming into these largely undeveloped communities, and the towns decided they wanted nothing to do with housing, at least below the CEO's office. So you had brewing in 1971 this fight about zoning developing in these cases essentially from the right. I will suggest to you that this is the attack on zoning coming from the right, or a libertarian attack, that zoning was an abuse of the governmental power, and the arguments were that there was a regional interest in the quantity of housing, in variety and choice of housing, that we needed housing that was going to house the baby boom that was coming of age, who had largely grown up in the suburbs. Were we going to make room in the suburbs for the kids of the suburbs? Jobs housing ratios mattered as a transportation policy, as an economic development policy, as labor force, and that artificially inflated costs were exclusionary. But I can tell you the charts that were done in those reports, as a young man I was laying them out on grid paper pre-computer days, every $1,000 in increased cost drove people out of the marketplace being able to live in that community. But that was an analysis that was strictly in the middle class. There was no discussion in any of this yet about race, income, relation of suburbs to city. And the zoning decision, Furman in Madison in 1971, the first trial court decision in this issue, reads from today's perspective like a libertarian scolding of local government. You can't use zoning to decide who gets to be a member of the club of your citizens. Now, that's the part that doesn't get talked about a great deal, and that's now in parallel with what's going on in Mount Laurel. Mount Laurel was a very unique place. This was a pro-growth municipality where the town fathers went to the first major single-family builder and asked him to add a multifamily section to his community, where they approved 2 very large PUDs, one of which won all of the design awards in the early 1970s, was on national magazines, the Birchfield development. And Larchmont was approved as a 6,000-unit PUD where a train station was expected to be built. The line never got built. Neighboring Morristown killed the train coming through their community. But here was a very pro-growth municipality approving over 10,000 units in a very short period of time. And it was in that context that a case about race, about a community that was trying to eliminate an existing poorer and minority community that was within its boundaries, was brought up. And now I'm going to jump over a bunch of history and leap to 1983. And the beauty of Mount Laurel 2 is it combined both of these attacks. The Walentz decision in Mount Laurel 2 took the builder's remedy, which said, by the way, production of housing is important, variety and choice in housing is important. But as part of the remedy, we know there's going to be a windfall. Zoning had suppressed values. As we release zoning, there's this windfall that's being created. And we're going to turn that to public purpose. We're going to do something that does affordable housing and addresses the racial and social issues that had been raised in Mount Laurel. So you get a sense from where we started in 1971, the array of issues that were being addressed in this judicial reform, that most of which are not being talked about today, and the complexity is very much lost. And on the panel today, you're going to hear from a number of people from very different perspectives. And we're going to talk about how we measure the success of what's occurred. And it is indeed how much price-restricted affordable housing has been created, but also how much housing of any kind has been created. Tens of thousands, if not hundreds of thousands of units in the state would not be here today if it were up to local government exclusively over the last 40 years. The diversity of housing that we have in the state goes back to this doctrine. Amendments that we saw, not just to COAH, but the State Planning Commission, the idea that we needed an articulated regional interest comes from this same fertile soil. And amendments to enabling legislations, that MLUL now has all of these letters, one of which is variety and choice, arises from this. And you'll hear that this has happened around the country. Enabling legislations have been amended to broaden the zoning foundation coming from the 1926 and 1950 decisions. And I'm going to now turn the panel over to address all these issues to Professor David Trout, who I'm very pleased has agreed to moderate this. He is professor of law and founding director of the Center on Law in Metropolitan Equity. He is a Harvard man, and many of the leading experts in our affordable housing field have been Harvard men. So we have to thank that august institution for giving us a lot of the brain power that has moved us along. His recent book, The Price of Paradise, has just come out this month, and I will embarrass him by saying that I got a hold of it. Amazon does not have hard copy yet. Otherwise, I'd hold it up and let you see the cover. I've got an electronic copy, and I've been reading. And I would urge you all to read this book. It is phenomenal. It is a very elegant treatment of race and planning, the importance of place in this discussion. And I think he's a very important new voice to the dialogue that we've been having here in New Jersey. So I would welcome Professor Trout, and he'll take this over, and I'm going to go run a conference. Professor, thank you very much.
Thank you so much, Craig. Good morning, everyone. Boy, it makes it easier to begin my remarks without having to engage in shameless self-promotion and tell you all about my new book. So, complete with a reader who's happy. That's nice. That doesn't happen that often. Craig mentioned how the cases of the last year or 2 years or so, the press coverage on Mount Laurel has brought it back into public consciousness. And I would suggest that it's a good thing that Mount Laurel is back. The New Jersey Supreme Court recently put new breath into a doctrine and its principles that many thought may have died a long, slow political and regulatory death. It's back, though. It's back to be reclaimed, to be newly defined, and to find its relevance in a state that still suffers from its primary malady, stratification, and its consequences. What those consequences are seems to depend on the particular room in which the question's asked. In a room full of housing advocates, the answers have a lot to do with racial and economic justice. In a room full of broader policy folks, it may be equity, particularly regional equity. Lawyers see it through the varied lenses of state and local government law, real estate development law, even civil rights. Planners, well, and it's so nice to be among you all, planners have to do and undo the landscape of residential organization in minute detail. So for you, Mount Laurel may represent the complex scheme of overlapping and contradictory imperatives. We're fortunate that this first panel considers the Mount Laurel doctrine, its framework, and current consequences in all of these ways. And that seems like the right thing to do because, to my thinking, Mount Laurel has always been about all of these things, wrapped up in the question of just what are the consequences in a state like this, and of the stratification of people, communities, and resources. In other words, it has always been about the costs of our arrangements to our municipal tax bases, our neighborhood stability, our paths to opportunity through local institutions, our regional competitiveness, and to ourselves as moral beings. So after writing a book about the spatial character of an inequality in the United States, I'm struck by how much the tangle of Mount Laurel issues represents what Martin Luther King, and it's appropriate to raise his name on the week we celebrate his birthday, what Martin Luther King called mutuality. From Birmingham jail in 1963, Dr. King wrote, quote, that somehow we're caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly. This is the interrelated structure of reality. The question of consequences raises the issue of just what kind of interrelatedness exists among New Jersey communities. Is it zero-sum, where mutuality is parasitic and competitive? If so, then it's hard to combat the urge to fiscal zoning, attracting the desirable and jettisoning the undesirable. There will simply be losers, perhaps big losers, and they may be the price our society pays for winners, big winners. Is mutuality instead neutral? We're just humming along in our fragmented lots, making decisions that hope to boost local opportunity, but like some idea of public goods, affect others, but never use up scarce resources. This seems unlikely. Interrelatedness in land use seems to suggest more interdependency than neutrality. Or perhaps mutuality is something to which we might aspire in a more progressive way. This is what I think Dr. King was suggesting, yet it may also be what the highest court in the state was saying back in 1975 and as recently as last September. The times, of course, have changed. We'll hear whether social stratification is as bad today as it was in 1975, but we know that economic inequality has widened. We know that poverty has spread to suburbs that in 1975 could never imagine it. We know that being middle class is harder to define now and trickier to sustain. We know that suburbs are the destination of choice for more and more recent immigrants, and that blacks populate suburbs, often fiscally weak suburbs, in numbers unimaginable in 1975. We know that a lot more is expected of our school children today than in 1975 because a lot more skill and competition characterize the workplaces that they will seek. We know that a great many places suffer from a fiscal stress that makes the basic level of public services available through local property taxes back in 1975 look downright luxurious. If this is not mutuality, it is at least mutual interest. The many critics of Mount Laurel argue against it on various grounds: inefficiency, localism, corruption, regulatory ineptitude, and basic notions of fairness. The court has at least answered that, despite criticisms and the substantial problems of administration, we must keep trying. The court recently affirmed the relative administrative independence of COAH. It affirmed the notion that the doctrine defines general welfare in regional, not local terms. And it did all of this work by interrogating the math of Mount Laurel, the complicated formulas on which we've relied for implementation of an abstract principle into facts lived on the ground. If Mount Laurel is important, urgently important to our lives and the state's communities, it is because its variables, affordable housing, regional distribution of benefits and burdens, access, balance, have consequences for all of us. That is, the doctrine's relevance has to remain in the consequences of stratification. It's not just the principle, it's the costs. Now, I can't promise that everything you'll hear on the panel today agrees with me about this, or that each panelist will speak to the costs that the Mount Laurel Doctrine either imposes or allays. But I put it out there as an important contemporary part of the Mount Laurel Doctrine and the broader issue of fair share housing schemes here and across the nation. And with that, let me introduce what is truly an amazing lineup of expert speakers in so many aspects of Mount Laurel. We have 5 principal presenters who will speak for about 20 minutes each, and they are Alan Malik, Senior Fellow at the Center for Community Progress and a Senior Fellow at the Brookings Institution's Metropolitan Policy Program. Alan has written frequently and extensively on myriad issues related to Mount Laurel. Stuart Meck, a professor at the Edward Blaustein School of Planning and Public Policy and the director of the Center for Planning Practice there. His latest article is New Jersey's Mount Laurel Doctrine and its Implementation, Under Attack but Safe, parens for now, close parens, published in the current issue of Planning and Environmental Law. Larry Lussberg, a partner at the Gibbons Law Firm where he chairs the Criminal Defense Department and its longtime director of the firm's John J. Gibbons Fellowship in Public Interest in Constitutional Law, which litigates historic cutting-edge civil rights and civil liberties cases. David Kinsey, a planner and visiting lecturer at Princeton University's Woodrow Wilson School and a partner at Kinsey & Hand, specializing in planning for affordable housing. He's been a court-appointed special master in numerous Mount Laurel lawsuits. Marty Birnbaum, a planner and lawyer who directs the National Center for Smart Growth at the University of Maryland and has many years of teaching in New Jersey and advising local governments here on a range of planning issues. That's a pretty extraordinary group, as are many of you, and many of you are familiar with them from your work here in the audience, and I'll make sure we have time for a healthy exchange between panelists and you after the prepared remarks are done. However, we're also extremely fortunate to be joined this morning, not entirely joined yet because I understand some people are still in traffic, but I'll introduce them in absentia in the expectation that they'll be here shortly, by an equally impressive group of expert practitioner respondents who will react to the speakers, or if they're not here to hear them, they'll react to broader issues. And they are, well, Jeffrey Serenian is here, who not only clerked for Judge Serpentelli, but is a leading special counsel to municipalities on affordable housing issues. Betsy McKenzie, I understand, is still en route, a planner with extensive expertise in affordable housing issues. Kevin Walsh, an attorney and director of the Fair Share Housing Center, who focuses his practice on regulatory challenges and litigation involving high-growth municipalities. I should add that although he's listed as becoming a lawyer in 2000, I've always understood Kevin Walsh and his colleagues at Fair Share to have been litigating New Jersey affordable housing cases since at least the Industrial Revolution. That's at least how it seems to me and my students. They've been very busy. And with that introduction, let's begin with Alan Malik and move on down the line. Thank you.
Thank you. And this does seem like old times in a way, though I would take issue when Craig commented that when the first Mount Laurel trial took place, the dinosaurs had just left. Actually, that's not true. There were still a few of them around rooting in the marshes of the Delaware River. But I must admit, I find it amazing that I testified in the first Mount Laurel trial, which took place in 1971, which is slightly over 42 years ago. Now, just for the record, I was 7 at the time. I was very precocious, but it's been a long time that this issue has been with us. And what I'd like to do today is try to provide a sort of a perspective on that, both where did it come from, what it meant, and some thoughts that I think other panelists will pick up and elaborate on far more detail and far more insight about what happened and where we go from here. So first, just looking at it from a broad historic perspective in terms of the significance of this decision, I think it's important to ask the question, why do we have suburbs? And I don't mean suburbs as physical entities in terms of lots of houses, but why do we have them as distinct political entities? And there are a variety of reasons, but arguably, and people have written about this for decades, the most significant reason that suburbs incorporated as separate political entities and fought for the right for zoning and so forth was the ability to use land use regulations to exclude. And I think it's important to have that in mind, that the fundamental raison d'etre, if you will, of suburban municipal proliferation in the United States, particularly in the northeastern United States, was the desire to exclude through the use of the land use process. And what's interesting, because Cray also made the point about right versus left being somewhat confused in this issue, that one of the issues where right and left are most confused is in the idea of using governmental power to regulate land use. And it's fascinating that even though many principled conservatives, mostly in academia, have written about the pernicious effects of land use regulation on the marketplace and on human rights, nonetheless, practical conservatives always defend exclusionary zoning quite assiduously. So in this context, I think it's important to understand that the Mount Laurel decision and other actions that were taking place in a few states around the country was a very radical step in terms of land use and planning and housing in the United States. And as such, could be expected to generate a certain amount of opposition, which it did. But over the period from 1983, when the Mount Laurel II decision was enacted, and sadly, from 1975 to 1983, even after the first Mount Laurel decision, was something of a lost period in terms of actual implementation because of the lack of specificity or clarity in the initial decision. But from 1983 till the present, Mount Laurel has had a very significant impact on the landscape of New Jersey. And I'd suggest it operates at a number of levels. First, a lot of housing, a lot of affordable housing that people earning less than 80% of the median income in their respective areas around the state could afford, has been built that would never have been built without it. I mean, the DCA website, which I tend to take with a grain of salt, refers to 60,000 units having been created as a result of the Mount Laurel decision. And even given some margin of error, because the numbers are not actually verified or tested very much, that's a significant number. And that's a significant achievement, and it's an achievement that is far better than all but a handful of other states around the country, and certainly not worse, I think, than any. And these include inclusionary units, units in tax credit developments, rehabilitated units, a lot of housing that was desperately needed, and that is, for the most part, in locations which give people reasonable access to jobs, decent education, and decent public services, have been created in this state. And one could argue that probably somewhere between 100 and 200,000 people are living far better today than they would have without that decision. And even though it is far less than what one might dream of, it is a very significant accomplishment and should be recognized. At the same time, I think, and I think Cray suggested this, the Mount Laurel created the impetus for rethinking a lot of land use regulations and has created a lot, besides the actual affordable housing units, has created quite a lot of mixed income housing, higher density housing, housing of different types that might not have been seriously put on the table by local governments in the absence of the impetus for Mount Laurel. Another thing that I think is significant is that Mount Laurel clearly established both the viability as a mechanism for creating affordable housing and the scalability in the sense that it could create significant numbers of units of inclusionary housing, which is the use of, if you will, internal subsidies or cost offsets or other things to create affordable housing integrated to varying degrees into mixed income, predominantly market developments. And this, today, I think most people, not everybody, but most people would say that inclusionary housing it's one of those things. It's part of it's part of the planning and the housing and the development landscape. And a lot of developers have become reasonably comfortable with it. It's not that long ago that not only the home builders, but seemingly progressive groups like Urban Land Institute, planners, others, had as almost an article of faith that mixing incomes in housing developments was just a terrible idea. And I think the fact that we've gotten away from that and we have normalized the concept of economic integration, even though we haven't taken it anywhere to the level that it could be, is very significant. We've also, through Mount Laurel, and I think this is something that is often underappreciated, put affordable housing very much onto the suburban management or operational agenda. And I think many towns across the state have affordable housing boards, affordable housing officers. There's even an association of affordable housing professionals, essentially made up of people whose job it is to manage the processes associated with Mount Laurel and the Fair Housing Act in the different municipalities of the state. And I think, in a sense, both the fact that this infrastructure has been created and the fact that Mount Laurel may not be loved, but is now seen, if you look at what local governments do, not just cities like Newark, Trenton, and Camden, but what local governments generally do. You look at the list of municipal functions on their websites, and you have public works and police and fire and animal control and affordable housing. And so this is significant. And so all of these things are, I think, very important and worth recognition. And I think it's unfortunate that it has not received the kind of attention, the kind of serious analysis, the kind of presentation that it deserves. I think it is a significant achievement and should be recognized. Well, as we all know, something went wrong. And why are we here today saying, what is the future of Mount Laurel? What is going on with this? And I think a lot of things. I'd like to suggest a few thoughts. I think the first thing is that as a political issue, I mean, again, if you think about the history of why we have suburbs and the underlying issue, as a fundamental matter, Mount Laurel is never going to be loved by suburban New Jersey. As the Housing Appeals Board is not loved by suburban Massachusetts, et cetera, et cetera. This is a reality, this is inevitable, and this will always be the case in all likelihood. However, the history of Mount Laurel, at least for some period of time, showed that it may not be loved, but it will be accepted. And that is a very significant distinction and a very important one. Because, if you're a public policy, it's nice to be loved, but it's not necessary. What matters is whether you're accepted. And what was clear, that it was accepted at least in large part because for a period of time, and I would say roughly from the mid-'80s till roughly the end of the millennium, there was, if not a state government commitment to Mount Laurel, that would be too strong, there was an acquiescence and there was a sense on the part of a series of governors and a series of administrators that the process should be allowed to work within reason, that COAH should be allowed to function within reason, and that this represented the court had spoken and we should let the process sort out. So as long as that was the stance of state government, then Mount Laurel worked, if not brilliantly, at least reasonably well. And I would say that the majority of suburban municipalities, not all by any means, but the majority accepted Mount Laurel and made a reasonable effort within their parameters to comply with the law. And I think if you look back at the list of the towns that came in and participated in the COAH process during this period, it represented, I would say, conservatively, of those municipalities that had significant development pressure, leaving aside New Jersey's multiplicity of tiny boroughs and distressed older cities. I would say conservatively 75 to 80% of those municipalities were participating in with at least a modicum of good faith in the Mount Laurel process. So I think within reason, within the limits of what you can realistically expect from a governmental process, the system was working. Now, this, what you might call an implicit social compact, was broken during the decade of the 2000s. And this is the tragedy of Mount Laurel. And I think when we look back at why we got to where we are now, I think there are a lot of different strands that came together. And I think we can certainly point to the, at best, ambivalence or hostility, mendacity, I'm not sure what the right term is, of state government during the decade, the top leadership of state government towards the Mount Laurel doctrine. But I think that's not the only story. I think there are other issues. I think the courts, while I think trying sincerely to uphold the doctrine, pursued a number of decisions that showed a remarkable ignorance of either planning or economics in terms of what they called for. I think in some respects, the advocates, in terms of pushing for larger numbers, higher definitions of what need meant and so forth, actually, in some respects, contributed to the problem rather than solving it. I think the whole dynamic of Mount Laurel during this period kind of disintegrated in distrust, excessive complexities. I think COAH took refuge in kind of increasingly bureaucratic systems designed to sort of micromanage the process. I think everybody shares to some extent in the disintegration of the Mount Laurel doctrine during that decade. So the upshot is, and bearing in mind that as a court-imposed doctrine, which few significant political figures ever actively supported it never had a residue of political legitimacy to any significant extent, that it was only a logical extension of all of that, that by the time Governor Christie began his campaign for office, it was available as a natural scapegoat that could be pointed to and used as a political football. I don't know that that's a rather bad mixed metaphor, scapegoat as a football, but I'll leave that aside. Maybe, no, I won't go there any further. But the point is, Mount Laurel at that point was ready to be used in the way it has been used since Governor Christie's election. So I'm sure Marty, Stuart, and others will talk about this more, because I think there are a lot of important lessons to be learned. Now, briefly, the question of can we put the pieces back together again? I think what we're looking at this point is, first, clearly, no remedy that relies on state enforcement can be successful where the state government is hostile to enforcing that remedy. That's almost a self-evident proposition. And so what that means, I would guess, is that for the foreseeable future, we are going to be looking to individual courts to impose individual decisions in individual cases. And I think that may grow over the coming years. And I think that runs the risk, of course, of the same situation that we all saw between 1975 and 1980, where you had individual courts imposing individual decisions that were all over the map. And there was no consistency and no logic because there was little guidance. So that's a temporary expedient, if you will, but not a true solution. And ultimately, I think we need a better framework for setting fair share goals. And we need to be able to distinguish between fair share goals and housing needs. And I think the conflation of the two over the last decades was a problem rather than a constructive effort. Because let's face it, housing needs in this state are vast. Housing needs in this state are never, or anywhere else for that matter, are never going to be addressed through programs of new construction. And I can go into the economics of that at great length, but you'll have to take it on faith for the moment. A program that is essentially a planning program focusing on the construction of incremental housing units has to be seen as something different than a global way of meeting total state housing needs. I think it would be very good if we had some kind of a comprehensive approach to meeting state housing needs. Ironically, in 2008, the legislature enacted A500, which, aside from repealing RCAs, created a vehicle for trying to do just that in the State Housing Commission and a mandated comprehensive state housing strategy. Now, I'm sure none of you are familiar with the work of the New Jersey State Housing Commission, because neither Governor Corzine nor Governor Christie has ever felt the slightest interest in carrying out what, at least on paper, is a legislative mandate to create and empower that body. But the point is, COAH, Mount Laurel, and the planning process are not a strategy to address all of New Jersey's housing needs, and we have to start rethinking what that is so we can come up with goals that are realistically achievable and find a balance between micromanaging the process versus giving away the store, which seem to be the only two approaches that were operative during the last decade or so. And then we have to start thinking about legislation. Probably not for the next few years. I don't think there's a huge amount of point in people fighting and working to create a good bill. Actually, ironically, a few years ago, the legislature, after an enormous amount of effort, both by legislators and by the housing advocates, did craft a overcomplicated, perhaps slightly confusing, but basically sound approach to a new way of dealing with the Mount Laurel doctrine, which was passed by both houses of the legislature and then vetoed. I mean, there's no point in going through that exercise again, and I kind of cringe when I read that Senator Lesniak is proposing to start up the process all over again. It's a waste of time until there's a governor who's at least open to working with the legislature on this issue. And then finally, I think in the original Mount Laurel decision, if you all remember, or in this Mount Laurel 2, the court said, in effect, you have to meet your fair share of affordable housing needs. And then, once you've met that, do your thing. Zone for 10-acre lots, if that's what you want, as long as you've met this housing need. Well, the effect of that principle was to divorce the affordable housing process from the larger planning process. Now, some municipalities made some effort to integrate the two, but many did not. And I would hope that if and when we do get to the point of looking at a second generation of the Fair Housing Act, that we also look at ways where that can, in fact, be truly integrated into the planning process, and to make the provision of affordable housing as integral a part of the planning process as, for that matter, the provision of expensive housing. Thank you.
Since we're reminiscing about the early 70s, in the early 70s I was working for the Miami Valley Regional Planning Commission in Dayton, Ohio, and it was the entity and this was a 5-county agency. It was the first entity to create a fair share plan in the United States. This was done voluntarily, and part of the motivation was that there were a lot of production programs, the 236 and 235 programs that dealt with rental and for sale housing, and they all went through the Regional Planning Commission for something that was called A95 review. I don't know if any of you recall what that was. And the commission really didn't have a way of evaluating this, but they knew they wanted to ensure that subsidized units, federally subsidized units, would begin to get dispersed outside of the city of Dayton and into the surrounding 5 counties, because the bulk of the units, in fact, virtually all of the units, were in Dayton. After the first edition came out, the director and the assistant director of the agency wrote an article for the American Institute of Planners about the plan. In fact, it was the first article on it, and it had gotten a lot of attention in the press. And it was done as a monograph. Well, if you go back and you look at the Mount Laurel 1 decision, and you read the concurring opinion by Justice Morris Pashman, in a footnote, the article is cited. So that's where the idea came from, and HUD, which was a really aggressive and progressive agency in those days and had a lot of money, began encouraging other regional planning agencies in the United States to adopt similar plans. David Listica and my colleague at Rutgers did a book on fair share allocation formulas, and we found places like the Denver Denver Regional Council of Governments and the Washington Area Council of Governments and a number of other regional agencies throughout the United States adopting fair share plans. And these were plans that weren't the consequence of legislation, specialized legislation. These were simply plans that the regional agencies got money to do. So that's sort of the background. And MVRPC had 3 additions to this plan. I did the allocation formula on the last version, and they no longer maintain it. So, a little reminiscing. I'm going to talk about the impact of the Fair Housing Act and what we know, or at least what we think we know. You know, there are facts and then there are facts. If you had to evaluate what the Fair Housing Act had accomplished over the years as part of a formal independent study, what would you want to look at? Well, number one, you would want to look at the number of rental, for sale, and rehabilitated units, and compare them against the goals set for the municipalities by the Council on Affordable Housing and the regions in which these municipalities were located. You would want to look at whether more or fewer households were paying 30% or more of their household income for housing. That is, the effect of the program on the housing market. I think you would want to do a random review of housing plans submitted to the Council on Affordable Housing, assess their quality, and see if COAH had evaluated them uniformly before they gave them substantive certification. I like to term this sort of a forensic activity. You know, you go and actually look at what the agency is doing internally, and this, to my knowledge, hasn't been done. You would want to look at how the municipalities were using their monies from their housing trust funds and whether they were actually going towards housing production or something else. You might want to look at whether municipalities had eliminated the various exclusionary devices that were identified in the Mount Laurel II decision, and they were very, very, very specific. Now, not all of these questions have been answered, and some of the answers raise more questions. I'm going to talk for the next few minutes about what has been written on the impact of the FHA, including some work that I've done. And part of this comes from this article that I have this month in Planning and Environmental Law. Some basic data. Of New Jersey's 566, now 565 municipalities, 245 received substantive certification under round 2, and 68 received certification under round 3. And this is, again, the same data that Alan was talking about. And as of March 2011, again, this is the latest data from the department, or from COAH, the Department of Community Affairs reported that since the FHA was enacted, there have been 109, 557 proposed affordable units, of which 60,242 have been built. That's about 55% of those proposed. And similarly, there have been 25,034 units proposed for rehabilitation, with 14,854 units completed as affordable rehab units, so about 59% of those proposed. Now, these totals exclude units that were built as a result of the builder's remedy and not under COAH supervision, so we really don't know the whole picture, okay? We don't really know the whole picture. The first study that appeared on the impact of Mount Laurel was written by Naomi Wish and Steve Eisdorfer, who is here in the audience, and it was titled An Impact of Mount Laurel Initiatives, an Analysis of the Characteristics of Applicants and Occupants, and it was in the Seton Hall Law Review in 1997. And what they did is they reviewed data on applicants and occupants of what you could characterize as Mount Laurel housing that was from the New Jersey Affordable Housing Management Service, which tracked this data as of 1996. And so this was approximately 7,500 occupants of low and moderate income housing and approximately 36,000 pre-screened applicants for such housing. And what happened was when you actually occupied an assisted unit, you moved from the applicant list to the occupant list. This study attempted to answer the following questions. To what extent is Mount Laurel housing available to residents of major urban areas? To what extent is this housing occupied by former residents of major urban areas? Secondly, to what extent is this housing available to African Americans and Latinos? And to what extent is it occupied by African Americans and Latinos? And finally, to what extent is this housing available to households who suffer the most acute housing burdens, female-headed households, large households, very low-income households? To what extent is it occupied by these occupied by these households? Now, I'm not going to try and summarize this study because it is quite complex, many tables. But there was really one or two striking findings to me. And the authors wrote, in summary, and they're talking about what they found, there have been housing units built that are affordable to low and moderate income households since the judicial and legislative intervention. They're talking about the Fair Housing Act. And at least as reflected in the characteristics of applicants, this housing serves households who had genuine housing needs. Second, if one considers the other Mount Laurel goals, our data indicate that the experiment has not been completely successful as thus far implemented. Based on the AHMS data set, the judicial and legislative intent to eliminate exclusionary zoning has not enabled previously urban residents to move to suburban municipalities and has not enabled blacks and Latinos to move from heavily minority urban areas to the suburbs. Now, there's data that I'm going to talk about that suggests that this has actually changed. There was an empirical study that was published by the Lincoln Institute for Land Policy in 2009, and it's called Smart Growth Policies, an Evaluation of Programs and Outcomes. And this wasn't aimed specifically at New Jersey, but it was interested, it looked at a variety of areas, and it was interested in the impact of state smart growth programs on housing affordability for the period 1990 to 2000, because we wanted a uniform data set. We wanted to use census data where we could. We didn't want to have to fool around with data that was hard to acquire. And the study compared Florida, New Jersey, Maryland, and Oregon, which all had programs that all of us agreed were smart growth programs in some way, against Colorado, Indiana, Texas, and Virginia. Tim McKinnon, who is now with the Rutgers Survey Research Center in the Blaustein School, and I were co-authors of this part of the study, and I'm just summarizing a portion of it. Tim got me over my fear of using SPSS. I don't know if any of you ever had to do that, but it's sort of frightening. But once you learn, it's addictive. The specific indicator for affordability, or its lack thereof, is the share of households in a community whose housing cost burden exceeded 30% of household income, and how that share changed over the decade by each county. So, for example, if the figure is 10% in 1990 and 15% in 2000, then the affordability problem is worsening. And the study used multiple regression to analyze the determinants of the shares of cost burden owners and renters. And it assumed that smart growth programs, which tend to constrain land for development, absent a requirement for affordable housing, were associated with increased shares of cost burden households. And the study observed the following. the regressions we ran hypothesized a uniform effect from smart growth programs, and they found a statistically significant relationship. In other words, the states that had smart growth programs had created cost burdens. Smart growth programs were associated with increased shares of cost burden households. Additional regressions that allowed each state to have an independent effect, I sound like I'm at a academic conference, found that the shares of cost burden owners and renters increased most in Oregon and least in Texas. But New Jersey and Florida, smart growth states that both required affordable housing elements in local plans, perform better than Oregon and Maryland for owners and better than Oregon, Maryland, Virginia, and Colorado for renters. And the study noted, we were curious, why did this happen? The study noted that during the period from 1990 to 2000, New Jersey added more than 24,000 units of new construction and rehabilitated units under the COAH program. The study goes on to state, while New Jersey's housing costs were high, its rental cost burden increased less during the 1990s than in the other smart growth states. In terms of rank, New Jersey had the largest share of counties adding rental units over the decade. Then the study undertook something called a pool regression analysis using Texas as the constant, and its results showed that New Jersey performed better than the three other smart growth states, as well as Colorado and Virginia, but not Indiana, in terms of renter affordability. So what does this suggest collectively? It suggests that for New Jersey, injecting affordable housing, particularly rental affordable housing, into a housing market that had been historically underserved by rental housing, especially in suburban areas, will have a positive impact on the renter's cost burden. And I believe that a more aggressive program with more new units built or rehabilitated probably would have had a stronger effect. Now, second question is the Mount Laurel anti-exclusionary zoning doctrine actually causing an elimination of exclusionary zoning in New Jersey? It doesn't seem so based on limited evidence. A 2011 report by Dr. John Haas, I think I'm pronouncing his name right, who's actually giving a session here today, of the Rowan University Geospatial Research Laboratory, evaluated this issue and concluded that at least within Monmouth and Somerset counties, exclusionary zoning still exists. Using a geographic information system analysis, the Haas report determined that residential development has, contrary to the State Development and Redevelopment Plan, this is the 2001 plan, followed a low-density, sprawling pattern that reflects continued exclusionary zoning. And further, commercial and industrial land uses have been more consistent with the state plan than residential. So it suggests the continuation of municipal zoning that welcomes retail and office development while discouraging high-density residential development. Many high-density zones that do exist are identifiably zones where Mount Laurel housing exists within the state plan's smart growth areas. And this implied, the report observed, that absent Mount Laurel, residential development would be even less dense and less coordinated with the allocation of jobs than current patterns indicate. The Haas report concluded that the case study counties were overzoned for commercial industrial development in terms of the number of jobs these areas may generate relative to the future housing that will be built under current zoning. More specifically, the jobs housing balance clearly favored jobs over housing. Now, what's the jobs housing balance? The jobs housing balance is a rule of thumb in the planning literature that really establishes a ratio of 1.5 to 1, with a range anywhere from 1.3 to 1 to 1.7 to 1. So the higher the number is, the first number is, the more jobs are being generated, and the pressure for housing is being exported to other areas. So Monmouth County zoning, according to the report, had the potential to create enough commercial and industrial floor area for, they're very specific here, 223,450 jobs with a maximum housing build-out of 33,177 housing units, which is a ratio of 6.74 to 1. Now, this ratio of nearly 7 jobs for every new home suggests that the zoning of commercial industrial land is not balanced with the zoning for residential land in Monmouth County. Now, in Somerset County, the results were even worse. The Haas report's analysis showed that Somerset County zoning had the capacity to provide housing for 14,802 residential units, and at the same time, it had the capacity to create 250,000 jobs as indicated by zone commercial industrial floor area, resulting in a jobs housing ratio of 16.7 to 1, significantly out of proportion with the accepted jobs housing ratio of 1.5 to 1 that I identified earlier. The report's analysis of build-out potential for commercial and industrial lands in Somerset County again demonstrates that municipalities have significantly overzoned for commercial and industrial development and underzoned for higher density residential development, with Mount Laurel related developments providing an exception to the general rule. So now again, these are only 2 counties, all right? So we can say that this applies to all of the state and that everybody is doing it, but it's, you know, I like to say sometimes the only 2 things you have are data and assumptions, and in this case, we just have data. Now, the most recent study was written by Stephanie Bush Baskett, Kelly Robinson, and Peter Simmons, who was my thesis advisor at Ohio State and is a law professor at Rutgers Newark, and is titled Residential and Social Outcomes for Residents Living in Housing, certified by the New Jersey Council on Affordable Housing, and it appears in the spring 2011 issue of the Rutgers Law Review. This study used a mail-based survey of 3,000 households between October 2010 and January 2011 from a list of 7,000 certified units provided by COAH in September of 2010. And the actual response rate, if you're interested in these types of things for the survey, because you always get questions on what the response rate was 18%, resulting in 402 completed surveys. Again, the results are difficult to summarize in a short period, but several conclusions stand out. And these are conclusions that deal with the social impact of living in Mount Laurel housing on the residents of that housing. First, the residents of the affordable units that the authors surveyed had overwhelmingly moved from urban to less urban municipalities, although the degree of this shift depended on how one defined urban. And overall, 3/4 of the survey respondents moved to municipalities with a lower population density. And this contrasts somewhat with the findings of the Wish Eisdorfer survey and may indicate the results of more units being available in suburban areas than in 1996. Second was the question of whether access to employment improved as the result of moving to a COAH unit. And most respondents didn't report either an increase or decrease in access to employment. However, even with the poor employment situation that we've had since 2008, respondents answered that they were far more likely to report being better off financially in their new community than where they had lived previously. Third was the question of whether the residents felt safer in their COAH unit than where they had lived previously. A large majority of respondents reported feeling very safe in their current residence. Approximately half of the residents reported feeling safer than their prior location, and only a small percentage of the respondents reported feeling less safe than previously. Finally, there was the question of whether residents of COAH-generated housing believed that access to schools had improved as a result of moving. Almost half of surveyed households that had children listed access to schools or better schools as one of their reasons for moving. And a very large majority, 85%, of those households with children reported that access to schools was very good. And the author summed up this, their study by saying, a substantial majority of affordable housing residents surveyed tell us they like where they live, they like their housing units better than where they had lived before, and they like their new communities better than their old ones. Given the opportunity to move, a majority of respondents said that they would prefer to stay where they are. So there you are, a mixed report card on the production of affordable housing, which could have been more than proposed, but a positive effect on housing cost burden as a result of injecting affordable housing into the housing market. Now, I imagine if you looked at this, the housing in more detail, the housing cost burden wouldn't be uniform, okay? But this is a statewide analysis. We still have exclusionary zoning, okay? But we really don't have a study on its extent throughout the state. And finally, the people who live in the units created under the Fair Housing Act like them and like the communities they live in, and we can conclude, believe their lives are better. Thank you.
Hi, everybody. My name is Larry Lusberg. I'm not a planner. I don't know anything about planning. And I'm not even really a housing lawyer. I'm a civil rights lawyer, and I know a tiny fraction about what you all are here to learn about today than what a lot of my friends in this room know. And I see Kevin Walsh, who is really the hero of the Mount Laurel litigation, Steve Eisdorfer, and Judge Bucksbaum, my friends who know so much more about this than I do. But I'm going to talk to you about my involvement in the last round of Mount Laurel, and with it, what I think that these cases, not only this case, but a lot of the most important legal issues in New Jersey are really about, and that's race. I filed a brief on behalf of the NAACP and the Latino Action Network in the last round of Mount Laurel, and I didn't get to argue it, so actually you guys get to hear what my argument more or less would have been. And interestingly, the court also didn't address those issues. If you read the most recent Mount Laurel decisions, they don't mention race at all. And yet I really believe that that's what's underlying all of it. I really believe that the race issues are one of the things that motivated the court to keep this doctrine alive. And I really believe that part of it was the fundamental position that we were taking and the thing that we were worrying about. You've heard today about just most recently about that it's a sort of a mixed report card. And it is. And to me, the mixed report card is the very reason why Mount Laurel has to live. On the one hand, it's done some good things. If it was accomplishing nothing, I think the court would have been not at all hesitant to jettison the doctrine. On the other hand, it hasn't done everything it should, and so its continued vitality was critical. And so from the perspective of my clients, minority groups, it was critical that we make both of those points, both that this is a good doctrine on the one hand, and that it was an incomplete one on the other. To that end, I was gonna, when I argue this, and what I'm gonna do today, much briefer than my colleagues, I hope, is make 10 exactly 10 points. I don't know why I always do things in 10. It's a little too much watching David Letterman or something. But so there's, and I should have done a PowerPoint with the 10 points so you could take it with you and wouldn't even have to listen, but so just listen for a couple minutes. These are the 10 things I wanted to say to the court, and then I'll say to you today. The first is that housing is, in fact, one of the key areas of inequality in general and of racial inequality in particular. Like many other areas of inequality, it both reflects and recreates that inequality. So like jobs, like voting, and until recently, at least in, not with regard to race, with regard to marriage, it is one of those things that both reflects the inequality in our society and then creates more inequality. So not surprisingly, it's a flashpoint. That's point one. Point two, residential segregation in connection with housing, continues in the United States. Today, half of all African Americans live in what's called hyper-segregation, and you can read the studies and get what that definition is, but highly segregated communities, and another 30% in what's known as high segregation. 3/4 of those living in high poverty areas are African American or Latino residents. So housing is a key area of inequality, and residential segregation exists nationally. That is also true in New Jersey. And by the way, for anybody who wants it, I'm happy to provide the brief that we wrote, which actually lays all of this out in detail and provides this data. But here's what it said. African Americans and Latinos are highly concentrated and disproportionately so in a few densely populated urban areas in New Jersey. You all know when I say that, that's true. I mean, we just all know that. Thus, and by the way, these areas are the lowest in the state in terms of per capita tax base. Thus, the 34 municipalities in New Jersey that have the highest percentage of African American residents, about 50% of all African Americans, have a median per capita tax base of $53,795. The 39 municipalities that have the highest percentage of Latinos, again, about 50% of all Latinos, have a median per capita tax rate of $84,055, while the state average is over $140,000. These are staggering numbers. Put another way, thinking about it another way, as you probably know, for anybody who's studied, for example, the Abbott decisions, New Jersey divides all of its hundreds of municipalities and school districts into what are called district factor groups, ranging from A to J, A being the lowest, J being the highest, based upon a number of measures having to do with education, employment, and income. The A, which is the lowest level, is 55% African American and Latino. J, which is the highest, is 6.6% African American and Latino. These are very, very stark numbers. So, housing is a key area of inequality. Residential segregation exists in the US. Number three, it also exists in New Jersey. The consequences of this, number four, are very dramatic in terms of everything from education and employment opportunities, exposure to crime, deprivation, and studies show even psychological stress, as well as the type of housing, as well as the overcrowded and substandard housing. So race equals poverty, and poverty in one generation begets poverty in the next generation, and all of this has a significant effect on quality of life. Today, the mean income for African Americans in New Jersey is $46,000 per year. For Latinos is $48,000 per year, and for whites is $77,000 per year. It is no surprise that that data is correlated, at the very least, with the housing segregation that I've discussed. Fifth, this, race, is what Mount Laurel was all about. We heard a little bit about this earlier, but Mount Laurel was originally brought by, you will probably know, by parishioners of the Jacob's Chapel AME Church, an African-American congregation in Mount Laurel, which was advocating for the construction of affordable garden apartments in their community. The court's decision that exclusionary zoning is contrary to the general welfare, this is Mount Laurel 1, was based specifically on racial segregation and on the social unrest that results from it. Mount Laurel sort of is viewed as this revolutionary decision. In fact, as those of the people in the audience who were around at the time and litigated it know, the decision was based upon other precedents under the New Jersey law against discrimination that, for example, allowed variances to build affordable housing because of the social needs to create adequate housing for minority groups in order to avoid what the court was concerned with, which was that slums, a word you don't hear very much, would exist in New Jersey, and you can look at the Supreme Court's decisions in Levitt and in David v. Vesta. But Mount Laurel, at its core, was a decision about race, and it's so interesting to see the evolution of it to where the most recent decisions don't even mention race, but respectfully, I think that's what they're really still about. Racial integration is also, and this is my sixth point, an integral part of Mount Laurel's legacy. It is really one of the reasons why Mount Laurel is viewed as a pioneering ruling. That's because municipalities with exclusionary zoning are in fact less likely to have African American residents. There's been greater desegregation in those regions of the U.S., the South and the West, where there is less exclusionary zoning, and there has been greater desegregation where there is more exclusionary zoning here in the Northeast as well as in the Midwest, even controlling for all kinds of other factors, including people's preferences on where they're going to live and socioeconomic status. So let me say that again. Why is Mount Laurel so important? It's because where exclusionary zoning exists, there are less likely to be African American and Latino residents. Seventh, for this reason, those who have supported the Mount Laurel decisions over the years, the Steve Eisdorfers and Kevin Walshes of the world, have met with the same resistance as other civil rights pioneers. In our brief, we talk about incidences where people in Mount Laurel, and Ethel Lawrence in particular, survived notwithstanding gunshots being fired into her bedroom window. This is the sort of resistance that you think of in connection with civil rights in the South in the 1960s, but it has been part of the Mount Laurel legacy here. And that resistance in much more subtle forms has continued throughout the course of this litigation. It's existed in the form of workarounds like RCAs. It's existed in the form of delays in legislation and in regulation. And of course, it's existed in efforts by the current administration to abolish COAH, just for example. This is the way we who do civil rights work, this is the world that we live in. There are no victories forever. They're just victories for now, and then you fight the next step. And if you lose, you yourself try to figure out new ways to get where you're trying to go. All of that said, Mount Laurel has made, in my view, and we're obviously talking about that in much more detail, and the others more subtly, has made huge progress. From the data that we hear today, and what we argued in our brief was that there have been over 60,000 units of housing built. Those units house over 160,000 people in 160 towns, not to mention 15,000 or so refurbished units. And here's the point. Where those units exist, racial segregation has decreased. And in our brief, we talked about particular towns, Mount Laurel being one of them, West Windsor, a growing, thriving town, being another. And what we see is that where Mount Laurel housing, in the blocks where Mount Laurel housing exists, there is simply greater diversity. It is not just more housing, it is not just cheaper housing, it is greater diversity in those very towns. And when you compare it, as we did in our papers, you can see that there's simply more African Americans and Latinos in the Mount Laurel housing than there is in other sections of the towns. I know that sounds so obvious and a truism, but that's the point of it. And because that's the point of it, it's at least to that extent a success. Moreover, it's a success because, as studies show, and we cited those. There are real results, real concrete results for these minority communities, not just better housing, not just more housing, but that the people who live in those houses have higher income, fewer are on public assistance, they have less exposure to what the studies called neighborhood disorders like crime, substance abuse, homelessness. They have less exposure to what the studies call negative life events like illness and loss of jobs. And they have better mental health, less anxiety and stress, better schools, and better schools not just because they're in good neighborhoods, but better in the sense that with that change in location comes more parental involvement, more hours spent reading, less school violence. These are the consequences of Mount Laurel success. Huge, real benefits. Ninth, there is still more that has to be done. We still need Mount Laurel to accomplish it. It has not, as you know, been fully implemented, partly by design. I mean, the Mount Laurel remedy was one that was to be phased in, and we have these rounds. This was, the last litigation was the third round. Partly because there's been non-compliance, which courageous advocates have been fighting. It's not, the goal of Mount Laurel has been far from fully accomplished. But 10th, it's critical that we do that we continue the Mount Laurel fight, because in fact, New Jersey has grown more segregated than ever in comparison to the rest of the country. In fact, in the decade of the 1970s, even as segregation nationally decreased, it actually literally increased in New Jersey by the types of measures that are used. There's something called the dissimilarity index, which I'm not smart enough to explain, but was happy to cite in our brief. That's what we lawyers do. But more to the point that once New Jersey started there, it remains, and you can see the charts, a more segregated state than not only the average in the US, but some scholars say it remains the most segregated state in the nation. And particularly Newark and Trenton suffer from astounding rates of segregation. So we argued in our brief that Mount Laurel was a great thing, but it was still needed. And that's the way we attempted to overcome the twin challenges of showing either that it had accomplished its goals, or number one, here was the problem. We had to show that it had not accomplished all of its goals, but it accomplished some of them, that it was effective, but not so effective that it was no longer needed. Those kinds of arguments are the kinds of arguments that we civil rights advocates face in all of our cases, just about every case. And at the end of the day, we try to argue that the reason that we should prevail is because what we're proposing is what's right and what's just and what's constitutional. But in fact, what we have to argue is the kinds of things that we're all thinking about today, which is, does it work? Is it still needed? We bear that burden, and I think that the most recent rounds of Mount Laurel litigation show that we can prevail when we make those arguments. Not only because what we're saying is what's right and what's just, but because the data prove that what we're proposing is both needed and is an effective way of getting to a fairer, more just, and really happier society for our clients. Thank you.
Good morning. Would you all like to take a stretch? Up. This is your chance. Okay. Okay, my name is David Kinsey. Now you may have a seat. And you may stay.
Stretch, not yoga.
I'm going to share with you some facts, some ideas, some hypotheses, assumptions, assertions, as a way of looking at what has been accomplished and has not been accomplished under Mount Laurel by, let's imagine, if it never happened. What if Carl Bisgayer hadn't filed that lawsuit? What if the courts had not ruled in the favor of the plaintiffs? How would New Jersey have been different? And I'm going to look at just several areas where change did take place and would have taken place. I'm not addressing race. That's been spoken about before. I'm not talking about sprawl. There have been changes and effects as well. But I am going to talk about, indirectly, 3 areas where Mount Laurel, I think, did make significant changes in the critical ingredients to build housing. There need to be sites, okay sites with zoning or land use approvals. Secondly, someone's got to do the development, and one way of increasing capacity is increasing incentives for people to get into that business, for profit and nonprofit. And finally, there needs to be money. And again, Mount Laurel did that in part by incentives for internal subsidies, in addition to some other flows of funding. So what was it like in the early 70s? The president was Richard Nixon, not very much of a proponent of affordable housing and opening up the suburbs. He adopted more of a wink-wink attitude toward compliance with the new federal housing community development laws of the late 60s. But the governor at the time, William Cahill, actually addressed the state legislature and said there's a housing crisis in New Jersey and it's time for a moral recommitment to addressing housing issues. Unfortunately, his actual legislative package was much weaker and eventually was not enacted. This was a period of time where one scholar, Michael Danielson at Princeton, wrote in 1975 in The Politics of Exclusion that most Americans are convinced that a decent home, nice neighborhood, and good schools depend heavily on the absence of minorities, and that was the spirit of the times. What happened to Cahill? He was defeated by Charlie Sandman in the Republican primary, who then lost to Brendan Byrne. So what would not have happened if Mount Laurel hadn't happened? Well, at least 2 state agencies would not have existed. COAH, established by the Fair Housing Act, and all that it has done and not done, all that it's done and the way it has done it and not done, none of that would have happened. And the State Planning Commission is another offspring of Mount Laurel too, because the court resurrected a dying effort at a state plan and made that the locus of where growth and affordable housing obligations would be concentrated, and invited the legislature to do what it did, is to create the State Planning Commission. New Jersey has changed in the past 4 decades. We were ranked number 8, and now we're number 11 by population. I would argue that much of that is for what I'll call the half-empty side of Mount Laurel, that not enough multifamily housing was built, could not be built for various zoning reasons. That's what I think would have happened without Mount Laurel. There would have been much less, a lower population, not 8.8 million, much, much less. And look at our growth rate in recent years. It's really low among the states. In 1977, state planners did a projection of what they thought the population of New Jersey would be in 2000. 9 million. They were wrong. Why the shortfall? Well, again, I would argue that part of the reason for the shortfall is inadequate zoning for multifamily housing to meet the needs of people. The baby boomers were just entering the household formation and housing looking at era, and there wasn't enough supply to help those folks. Housing types have changed dramatically in this period in New Jersey in one category. Look at the attached housing increase over the 4 decades. That's townhouse development. Townhouses, townhouse communities proliferated all around New Jersey in this period. And it's striking, I think, that the percentage of single-family housing is exactly the same. So there was a change, more compact development in attached housing, but again, I would argue not enough. Alan Malik made the good distinction between housing need and fair share goals. And Alan's been a long-time analyst of housing need. In 1970, he did some of the initial analysis by the Department of Community Affairs that led to this 1975 study by, again, the Department of Community Affairs, who pointed out that the state had a need based on physical characteristics for about 300,000 plus units. And then the state also said that there was a financial need. In other words, the state actually said that there were cost-burdened households, and that was a problem, and something should be done about it. And the definition of cost burden was only 25% in that era. And they concluded that the state needed 500,000 low and moderate income units. There have been other need calculations. Just for reference purposes, these are the numbers that COAH came up with in the last iteration in 2008. New units, 100,000 plus for new households. Housing in need of rehabilitation, much less, 51,000. Cost burden households weren't addressed, but others have been addressing it. And I think this is striking, that working households in New Jersey, half of them are severe cost burden. That's more than 50% of income for housing, and that's currently. Okay, so you've heard the number, 60,000 units have been built around the state. Here's the breakdown. And by chart and by table and pie chart, I think one of the interesting things is the percentage of 100% affordable housing. If you made this chart around 1995, 2000, there would have been far more inclusionary developments, but clear public policy made a shift toward favoring 100% affordable housing developments. The rental housing built with low-income housing tax credits has also been mentioned. No precise accounting of the double count in these two kinds of units has been made, but just to note that there are some 27,000 tax credit units, but there's still, of the affordable units in inclusionary developments, 17,000 or so around the state. And money has been generated in several sources. One no longer exists, regional contribution agreements. I think that's a good thing that they no longer exist. It's important to remember the realty transfer tax has generated funds, so it's practically $1 billion. And divide that by what, $100,000 per unit? That's a real number of housing units that have been facilitated by the funding that would not have happened absent Mount Laurel. The spatial distribution of these units indicates important things of what would not have happened. The blue are the towns that actually built a fair amount of affordable housing. And those blue towns would not be blue. They would be more, my guess is, on the orange or pink way, and the other colors would have changed as well. Much less affordable housing would have been built. Migration is another issue. This table is restricted to my commuting to New York City, but there are other kind of commutes that take place. But notice how purple Pennsylvania is, Pike County to the northwest. People are commuting, people are driving to where they can afford a house, and then they commute back to work in Morris County, back to work in New York City. There's been lots of out-migration in New Jersey, particularly of those of lower incomes, those below the median income. And particularly, we've had a net relationship in migration with Pennsylvania. State planning would have been different. In 1977, the Department of Community Affairs had a division of state and regional planning, which came out with this preliminary guide plan, lopped the state up into various kinds of growth areas. That's the plan that was resuscitated by Mount Laurel II, even though Governor Kane had just abolished the Division of State and Regional Planning. And now we have, as a result of Mount Laurel II, the State Planning Commission, the State Development and Redevelopment Plan, two versions of it. But what has been accomplished? Has it been significant in shaping the way development has taken place in New Jersey? No, according to the careful and very important studies by John Hass at Rutgers. Look at the percentages of growth that has still taken place in the rural and environmentally sensitive areas. If you look at the Pinelands Commission, the results are very different. Again, the Pinelands Commission has teeth, the State Planning Commission does not. Local planning changed dramatically as a result of Mount Laurel 2 because the Fair Housing Act amended the municipal land use law to require a housing plan element. So if a town wants its zoning to be valid, it must have a housing plan element. Of course, they have different qualities, different amount of documentation, analysis, and proposals, but at least housing is part of the municipal conversation. It must be addressed at the risk of invalidation of zoning. And finally, let me conclude with 3 points. But first, I'd like to echo James Carville, Bill Clinton's first campaign manager when he ran for president, except I'd say it's the zoning, stupid. It's zoning that shapes how our land is developed and who gets to live where. And Mount Laurel has made some changes, but there's more change that's necessary. Secondly, I think the glass on Mount Laurel achievement is half full or half empty, depending upon your perspective. From a national perspective, as Stuart pointed out and Alan as well, New Jersey is a leader, or certainly was up until a decade ago, in the amount of affordable housing production, particularly compared to every other state with maybe the exception of California and Massachusetts. So the glass is really half full. But from the insider's perspective, people in this room, I think you all know, and people who are New Jersey focused, it's really half empty. The potential is much, much more that could have been done. The last 13 years of a de facto moratorium by a bipartisan coalition of governors and their cabinet officers has stymied the affordable housing production that's still very much needed and could have been built. And finally, on a good news story, I get to plug a book as well. My colleague at Princeton, Doug Massey, led over the past several years a comprehensive study focusing on what's the impact of Mount Laurel, and focusing just on one development, a special one, Ethel Lawrence Homes in Mount Laurel Township, and looked at 3 different areas of impact. And first, we found that there was no adverse impact in terms of crime or tax increases or any things that were complained about would happen in Mount Laurel Township compared to its adjoining municipalities. Secondly, no adverse neighborhood impacts on property values. In fact, some of the neighbors in some of the developments you see around weren't even aware that there was Ethel Lawrence Homes, a 100% affordable rental townhouse development in their neighborhood. And finally, for the residents themselves, we had a perfect control group because we had access to those applicants who did not have the good fortune to be able to move to Ethel Lawrence Homes. And so we looked at the 2 groups, and in particular, the school kids who were able to go to school in Mount Laurel have done spectacularly well. Much less stress in their life. They don't hear as many gunshots. They have a quiet place to study in their homes. Their parents are more involved in the PTA. It's a good news story. Climbing Mount Laurel, affordable housing, and social mobility in an American suburb. You can get it on Amazon. It's ranked about 260,000. But all royalties go to Fair Share Housing Development, the nonprofit that built Ethel Lawrence Homes. Thanks. Let's see. There.
Good morning. You still with us? When I looked at this panel and I looked at the program, I realized that bona fides for this group really go way back, and the generational issue makes me a little bit uncomfortable. And then when I looked at a 3-hour session, I said, this is like a teach-in. And I don't know how many people still know what a teach-in is or was, but I'm not going to cover all of the ground that's already been covered. My remarks were iterated by some of the previous speakers, but let me talk a little bit about what I've been doing for the last couple of years and what I uncovered and how it might be useful going forward. My work is still a work in progress. My writing was designed to achieve a number of purposes. I've drawn from the works and interviews of more than just a few people on this panel and more than a few people out in the audience. I tried to make the work interesting, so I turned it into sort of an Anthony Bourdain tour of New Jersey. It began with a 3-hour tete-a-tete with Cray Runkamp in a TikTok diner until we got thrown out there, and I met with Kevin Walsh in a great Italian restaurant in Collingswood, and with Alan Malik in a Panera Bread in Freehold. So I traveled all around the state talking to people who've been involved in this issue for most of their professional lives. I have bona fides that go way back too, but I won't go into them. But I was less intensely involved in the Mount Laurel decision than many of the speakers today and some of you in the audience. The dictum that I followed, it was once conveyed by Proust, who said that the voyage of discovery lies not in seeking new landscapes, but in having new eyes. So I hope that although I was less intensely involved in some of these issues, I may bring new eyes to the situation. My first purpose was to try to set a larger context, and I'm currently immersed in this process, and that was to try to understand the limits of judicial intervention, the Mount Laurel decision and the Abbott decision as well, and what the Supreme Court was trying to do in the 1970s, and how that's played out over 40 years since those decisions began. With Abbott, it was Robinson v. Cahill at that time. And during part of that period, at least 19 years, I was part of state government. So I think I began to understand what went on inside and given the politics and public administration that was taking place. So then this is the second point. I'm attempting to understand these entangled public policies from a more narrow perspective of public administrators working within the state bureaucracy. In this way, my perspective is less about planning per se, but a mix of planning and public administration and law and the politics. And I have a special empathy with directors in the state level who often serve at the pleasure of political appointees who are much more political than they are, who are concerned about their jobs, but also trying to do a good job. And I therefore tried to understand the planning and policy perspective of the directors of the Council on Affordable Housing, and I talked extensively to each of them and what their experiences were like over the last 35 or so years. I came to the conclusion that these directors are really dealing with wicked problems, and this has been stated in other ways by some of the earlier speakers. Wicked problems are problems that planners refer to that never quite get solved. More likely they get displaced and pushed off the political plate. Race and class are certainly these wicked problems that we recurrently deal with but never adequately get addressed or resolved. And then we put people in some impossible jobs in public administration. Academics have written about these impossible jobs. Impossible jobs are where professional skills has only limits, where constituents are often intractable, and where available inducements and sanctions to change behaviors to meet the public policy goals are severely constrained. And this is what I got from my discussions and interviews with the directors. I suspect that this will continue now that we're beginning to hear more and more from our politicians, public officials about growing social inequalities, that they too are once again beginning to focus on some of these wicked problems, and that some of us will rise up to try to do some of these impossible jobs. To go to my conclusion, I don't know if people are familiar with the book or the movie When Harry Met Sally. At the start of the book, the movie, Billy Crystal gets in the car with Meg Ryan, and he reveals an intimate secret to her that He always reads novels from the back to the front. That way, in case anything happens to him before he finishes the book, at least he knows how it ends. So I'll do the same here in case anything happens to me before I finish. Very briefly, and this has been stated by previous speakers, it's my contention after studying this for the last couple of years, the situation that COAH operated fairly effectively from the end of the Kane administration throughout the Florio administration and until the end of the Whitman administration for approximately a dozen years. Since the early 2000s, the agency has, for the most part, ceased to effectively function. And then once that situation and those facts were uncovered, my immediate task was try to better understand why that was the case. I'm pretty close to what Alan Malik has described with my own looking at the facts. Relating to state government administrations, I found that the Kane and Florio administrations were mainly focused on a kind of startup phase, implementing the Fair Housing Act, putting COAH together, bringing the stakeholders to the table, devising a formula, writing the rules, attempting to implement the rules that would begin to structure and guide an administrative process. The Whitman administration struck and maintained a very delicate balance where none of the stakeholders were ever really happy with the process or ever really happy with the outcomes, but somehow they stayed at the table because COAH, as was previously stated, and Mount Laurel were never really loved, but that they expected that they would get something from the process, and it provided an alternative that was better than all the others that seemed to be out there. The housing advocates, the developers, the municipalities were the major stakeholders. People I interviewed all complained and griped about the nature of the process, the nature of the outcomes, but it appears that throughout the Whitman administration, they pretty much stuck to it. There were two mistakes made during the Whitman administration. I don't know if they were obvious at the time they were made, but they come back to haunt the agency. The first was to make the DCA commissioner the chair of COAH. That led to its further politicization. And the second was to postpone the third round until after the next census, which seemed reasonable at the time, but became a major problem once the new administration was inaugurated. The McGreevey and Corzine administrations proposed to change the formula to growth share. That discussion about growth share began with the best of intentions and came from some unexpected quarters. However, the delicate balance was upset. There was bureaucratic bungling that became evident. There was the repeal of the RCAs. There was political manipulation of the numbers. And as was previously described by earlier speakers, the agency's credibility was lost. This was only exacerbated by the burst of the housing bubble, so that the building industry had to recalculate its own approaches to these issues and its whole pricing mechanisms. But in general, whether it was the intention, the design, or inadvertence, COAH was an agency that everyone loved to hate and became a very easy whipping boy for political attack. This only became more obvious during the Christie campaign, even before he took office. His attack on the agency was only exceeded by his attack on teachers. And he also attacked the New Jersey Supreme Court to undermine its credibility, the constitutional foundations of affordable housing, his attempts at executive reorganization, an attempt by the state to take housing trust fund money and use it for other purposes, and eventually pushback by the courts. These attacks were less ideological, as previous speakers have pointed out. They don't fit neatly into right-left distinctions. I think they were more demagogical, if that's a word. It was a way for the governor to appeal to his suburban constituents and focus a lot of negative attention on an agency that at this point had no supporters. Why this political administrative history? Was this inevitable? I talked to a woman who's not around in New Jersey. I had extensive phone conversations with her who did not object to being quoted, Joanne Harkins, who watched a lot of the situation from the builder's perspective and now lives in Phoenix, Arizona. So she's got sufficient distance between New Jersey and herself. But she feels that it was almost inevitable, given the nature of what New Jersey was, that eventually state politics would catch up to COAH and undermine its effectiveness. I'm not so sure, but that was a question that she posed to me. But I did want to look deeper and try and figure out why COAH followed this history of a dozen years of relative effectiveness and then the last dozen years or so of relative ineffectiveness. I looked at questions of New Jersey's suburban culture and the fact that the predominant culture of the state is suburban. And I looked at the earlier works of Michael Danielson, who wrote right after the first Mount Laurel decision and predicted in 1976 that the state government could not be expected to be a reliable partner in terms of affordable housing, and provides quite a lengthy analysis for why he believed that to be the case. I read Alan Karcher, which many of you are probably familiar with, in his Multiple Municipal Madness, and the number of municipalities that the state has and the problems that that presents in terms of zoning. And Elizabeth Cohn, a Harvard historian and sociologist who grew up in Paramus and lived quite a while in Montclair, who writes about the historical sociology of New Jersey and how New Jersey is the quintessential suburban state and how this creates problems in terms of accomplishing or overcoming the difficulties posed by exclusionary zoning. I looked at the shrinking federal role and the fact that the court, although somewhat courageous in its Mount Laurel decisions, was really flying against the prevailing winds and hitting the headwinds of the federal government, significantly withdrawing from this field. And there were serious questions as to whether the state would step up, could step up, and whether COAH, the administrative agency that was established to implement these aspects of Mount Laurel, could do that in the absence of continuing federal support. I looked at the inherent limits of inclusionary zoning, and I looked at a lot of the work that's been done by Alan Malk, who's really an expert on this field, and I came to understand how limited inclusionary zoning is as a planning tool, that it's really market-based and very different from the kinds of Keynesian economic tools that we grew accustomed to in the 1960s, and that it really had its limits, and that COAH couldn't be expected to carry all the water for a comprehensive housing policy, and that the state really needed a more comprehensive policy that inclusionary zoning might simply be a part of and not the entire policy. I looked at the state plan, which I was more intimately involved with for a considerable portion of my state government career, and I began to understand the disappointments of this failed marriage between COAH and the State Planning Commission. The drafters of the two acts had anticipated that the Fair Housing Act and the State Planning Act were to be twinned, and that somehow the State Planning Commission and the Council on Affordable Housing would march off like Charlie Chaplin and his bride at the end of modern times to live happily ever after. But the two agencies appealed to very different constituents. And despite early efforts to try to write a memorandum of understanding at the outset and to try and make nice, over the course of 20 years or so, there was a complete breakdown in communication, so that in the last half dozen years or so, or I interviewed one of the directors of COAH, she didn't seem to understand the relationship between the State Planning Commission and COAH, and that in fact admitted to the fact that there was no communication between the two agencies. So the lessons learned, looking ahead, I concur with my esteemed colleagues here up on the panel. COAH has mixed results. It did better over its first decade or so, rather poorly over the last decade or so. Expectations were probably too high, given the cultural, political, legal constraints that it faced. Yet COAH can take pride in the accomplishments throughout its first dozen years, and they should not be lost. We should learn some lessons from them. And even if most of the stakeholders who were involved with the agency never were entirely satisfied with either the process or the results that were produced. Bouncing off of some of the things that David just said, I found that in addition to the housing allocation numbers, which became a major preoccupation of both the agency and the counties and municipalities that interacted with the agency, a workable forum was created. Contentious parties resolved at least some of their differences, and some affordable housing, a significant amount of affordable housing, was constructed as a result in places where it otherwise would not have been built. These achievements stood for the court's proposition that these matters could not simply be left to local jurisdictions, which tended to plan in ways that undermined regional and state interests to the detriment of all the state's residents, and especially to its poor and minorities. After 2002, agency politicization undermined its relative independence and ultimately the agency's credibility. This was achieved by politicians who came to office with very little empathy for the agency, for Mount Laurel decisions, for COAH operations. Some called this the reign of the mayors. As a result, COAH's difficulties in facing society's wicked problems became even more difficult, and for those holding those jobs in the state bureaucracy, their jobs became even more impossible. The major mistakes, as I see them, was number one, making the DCA commissioner COAH chair, number two, postponing round 3 rules, and number 3, proposing growth share to change the housing allocation formula, and then politicizing that approach. In addition, the limited nature of COAH's tool set, especially in the face of shrinking federal government housing role, the dysfunctional relationship with the state plan, and then changing market forces, including the burst of the housing bubble in 2008, requires a significant rethinking in all of these regards. What does this mean in terms of looking ahead? Well, I'm reminded of the Yogi Berra quip, "It's tough to make predictions, especially about the future." Or perhaps more to the point, Mae West, who once said, "I used to be Snow White, but I drifted." So these kinds of things are risky. Nevertheless, I conclude by offering the following, and I hope that some of these questions, concerns are taken up in the afternoon session, which will spend more of its time on looking ahead. I think we should take note of the lessons learned. COAH should not simply be discarded or cast aside. We should try to build on those lessons, not ignore them. For example, we need to acknowledge that there was a wide range of experience with municipalities. Some even embraced their regional housing allocation numbers and stepped up to the plate. Others, public officials looked to the state to blame, but went along for politically expedient reasons. And still others, there was resistance. When I worked at DEP, we talked about the importance of identifying the leaders, the followers, and the laggards, and the need to tailor different treatments in terms of developing and enforcing environmental policy in each of those regards. I think we need to do the same moving forward. We need to know more about what went on at a finer grain level within municipalities to better understand what were the factors that led to some municipalities leading in this regard, others looking for someone to blame but going along, and still others to just decide to resist both the Mount Laurel and the COAH impacts. How do we explain the differences? What was the nature of the range of experience over the past 3 decades? How do we close the gap between those who were outstanding in terms of leading this effort as opposed to those who were really resistant to this effort? And we need these tailored treatments. Number 2, we need to take note of the changing housing market situation. Where is growth likely to go? What are the changing demographics of New Jersey? What are the social and economic conditions that we are likely to face in the foreseeable future? How do those changes factor in to the changing risk-reward calculations of the development community to make affordable housing a reality? And then the third factor, last but certainly not least, how do we address the growing social and economic inequalities in this society? And the inability or relative inability of COAH to adequately address the question of racial and social injustice, given New Jersey's high degree of persistent social and economic segregation. In some ways, we're living in a more complicated age in terms of these issues. There's a book that recently came out, written by a fellow in California, and he talks about, the book's got a kind of convoluted title, but he talks about theorizing about discrimination in an era of contested prejudice. And what he says is that in an earlier period, overt racism was much more fashionable than it is today, so that in this day and age of contested discrimination, the language is likely more to be about fiscal impacts and property taxes and traffic, and much less about racial discrimination. But because of the legacy of racial discrimination, these governmental institutions continue to reinforce that degree of economic and social segregation coming out of the past. How do we get at those issues? So that needs to be addressed as well. Meaningful reform needs to take into account and restore the workable balance to address all of these concerns. A delicate balance that was delicately maintained for about a dozen years, but was then lost over the last decade. Thank you.
Thank you, Marty. So that concludes the remarks of our principal presenters. We started late for obvious reasons. We probably can't extend too much longer than our allotted time because of lunch. So that leaves us with about 45 minutes. I want to make sure that we get audience participation because I know you all have probably been champing at the bit as you've listened to so much so far. But we do have our three respondents, Kevin and Betsy and Jeffrey. And why don't we go in reverse order, if that's okay? Jeffrey Serenian.
Good morning. My perspective is the municipal perspective. Have a firm, we represent only municipalities. I think we have roughly 45 municipalities that we represent. I want to begin with the Supreme Court decision from just this past September. And I don't want to talk so much about the rulings as about the tenor of that decision. And to me, what was really very significant about that decision was it was the Supreme Court reaching out to the legislature and to the governor and pleading for another alternative to the way the doctrine is presently structured. You know, to me, I read the decision, and between the lines, what I saw a court that was recognizing that this doctrine is threatened to crumble under its own weight, because the compounding burdens, cycle after cycle, is resulting in just enormous pressures. And I think the Supreme Court saw the writing on the wall that Wilentz did not see when he wrote Mount Laurel 2, and realized that there was a need for a change. And the opinion just screams out for, give me an alternative. I'm going to show you a lot of discretion, but give me an alternative. Things that were sacrosanct from the Mount Laurel doctrine, the numberless approach, they said, well, maybe we'd be akin to that. Things about fixed numbers to be defined in fixed periods, they said, well, we'd be amenable to a change of that. The builder's remedy, that can have a different role too. You know, they were explicit. No elements of the remedy that they fashioned in Mount Laurel 2 were indispensable. That was their language. So we're at a time right now where it's a time of opportunity. It's a time of opportunity for academics, practitioners, and most importantly, legislatures to rethink this doctrine and to think, well, how can it work? And how can it work more effectively? And what I'd like to talk about briefly about is some principles that from a municipal perspective I would like to see in the doctrine. And I think that you know, Alan Malik, which I thought was a very, very interesting speech, made a distinction between the need and fair share allocations. And to me, one of the principal elements of any new iteration of the doctrine is you need to give municipalities attainable goals. If you're just going to focus on the need, you're going to be able to make the case that that need is enormous, and that you start adding on cost burden households to this. You know, you have a doctrine that imposes such overwhelming burdens on municipalities that it backfires. You force municipalities to dig in. You force legislators to dig in. The optimal climate for the most radical change to the doctrine, for the stripping down of the doctrine, is over-the-top fair share numbers. For all the housing advocates, for all the developers that are saying, let's get those numbers, you know, way up high where they need to be, nothing could be more detrimental to their interests than that happening. That would be exactly what it would take to galvanize people from both sides of the aisle to have radical legislation. You know, Alan Malik spoke about, he was correct, you know, municipalities aren't going to love this, but you need to foster public acceptance. That is true. Alan Malik said that, and John Payne, in the article that he wrote that the Supreme Court referenced throughout that opinion, understood the importance of trying to foster public acceptance. And a critical ingredient to that is give us numbers that we can attain. Any new iteration of the doctrine, I think, also needs to recognize, I mean, what happened in the past was we focused so much on what the need was and how to properly allocate it, we often lost sight of the forest for the trees. Because what would happen oftentimes is you'd get to the end game and you would say, well, okay, so Town X has a number of, in the case of Middletown, it was like over 2,000 if you add all 3 cycles together. And you look at the demographic profile of this municipality, and you look at all they had done and all the diversity in their zoning, all they had done that resulted in the creation of housing that, you know, over 30% of the households were low or moderate. You know, there needs to be an understanding. We need to look at the forest for the trees, and we need to quit focusing so much on the formula to be able to look at the end game and say, is it really reasonable that a town that really hasn't used its power to exclude low and moderate income households is going to have a burden of thousands of units? And I think that needs to be built in the process. Someone needs to test the end game. Where does it lead us with whatever formula you come up with? Another, in an ideal world, another principle that would be great to see in the doctrine is, you know, the doctrine has operated in a from top-down perspective. We come up with these needs and we impose them down on municipalities. You know, the intent being, I think what was in the Supreme Court's mind was that there be some measure of balance in the municipal ordinances of each municipality, that they don't just zone for the rich, they don't just zone for the factories, but they have multifamily housing, affordable housing. And I think that, you know, there's such a diversity of municipalities in the state, and models that are more premised upon the realities of each municipality or categories of municipalities, I think would end up making more sense than this top-down approach. By way of example, you have a lot of municipalities that are fully developed. So what's reasonable to them? You can give them a number over the moon. It's not going to happen. So what is a reasonable result? Should every project that gets redeveloped have to have an affordable housing component? What's reasonable for them? Municipalities that have no sewer and water, there's a lot of those, southern New Jersey. You know, what's reasonable to them? Towns that grow at the rate of 1 new household a year or at a negative rate, you're going to impose an obligation. You need to understand that that's a different category of municipality where a top-down approach doesn't work. Municipalities that rely on transfer development rights, the new enlightened way of controlling the use of land. Well, you know, maybe those approaches will result in a number of affordable units that would be less than the number that would result from a top-down. But in the end, you'd have a community that is well-planned, and that does result in a significant number of affordable units. The other aspect of this doctrine that I do not think has received enough attention, that I hope receives more attention in any future iteration, is, and Cray referenced this in his introductory remarks, the intent of the Supreme Court, when you look closely at Mount Laurel 2, is what they were trying to do is, yes, they were trying to give developers enhancement in zoning within the bounds of sound planning, but their intent was to mine the value of that enhancement and there to be a relationship between benefits and burdens with, in their mind, 20% being the minimum. You know, too often developers say this 20% is sacrosanct. And I think that if we looked more closely at the economics of inclusionary development, we would find A, that they could maintain a higher set-aside, or B, that they could develop at lower densities. The main pushback to the Mount Laurel doctrine from so many municipalities is the radical increases in density of projects in the neighborhood. It has not been, in my experience, an opposition to low and moderate income households. It has been the opposition to the overdevelopment that often results from the doctrine. And I think that if we had projects that were developed at lower densities and fit better into the community, you'd get a lot less pushback from municipalities to the doctrine. And finally, any new iteration of the doctrine, I think, needs to deal with some of the problems that were created by the Roberts bill in terms of development fees. The intent being that they were trying to accelerate the expenditure of these trust fund monies for their intended purposes, but there are some aspects to the way that bill operated that if we're going to redo the doctrine and have new legislation, we should address. For example, we should have a definition of commit to expend that facilitates the expenditure of these trust fund monies on affordable housing. We should not require court towns to have to go to COAH to get approvals of their spending plans. They can get it quicker and have it competently done in court. And under no circumstance should the failure of COAH to approve spending plans be a basis for COAH to somehow take these trust fund monies that municipalities very much need to fund the programs in their plan. Thank you.
I will try to keep it short, which is not my reputation. I think one of the things that I suggested to Cray when he called me about this that I'd like to talk about was that I think that initially when, certainly when Mount Laurel 1 came down from the Supreme Court, and even when Mount Laurel 2, probably even more when Mount Laurel 2 came down from the Supreme Court, there was a lot of public resistance to the idea that developers could walk into a town and say, I want a certain high density of development, and I'll do some affordable housing for you, but I want this high density of development. The whole idea of developer-driven land use decision-making was horrifying to towns. I think, however, that with the adoption of the Fair Housing Act, which gave towns a voluntary alternative, and with the, during the period of time, I would say, up to the late 1990s and into 2000, perhaps up to 2000, as towns began to understand that as difficult as COAH could sometimes be because of the regulations, there was a willingness to work with towns to try to get them into compliance, to allow them to have some control over their destiny. And I think during that period of time, a certain sort of positive attitude developed among people in municipalities, people in local government about affordable housing, and an understanding that it's something that in fact could be accommodated in a way that didn't have to threaten the fabric of the municipality or undo the basic zoned underpinnings of the municipality. And I saw this developing, I think, however, and I've got some really good examples of how towns went out and actually very positively attempted to create affordable housing opportunities. I would say, however, that since 2005 or 6, when there was a slowdown in getting plans approved and the rules had been were being challenged, and then ultimately the rules were thrown aside, and there has been no movement on the part of the legislature to come up with something better than the Fair Housing Act, no movement, no interest on the part of the current governor to take any kind of a leadership role with respect to affordable housing, and no ability, because of the governor's actions, for COAH to reestablish itself. I think there are a lot of talented people that were working at the Council on Affordable Housing as staff members whose talents were frankly wasted by the inertia that has hit since the mid-2000s. But I think that there were some very positive examples. I want to give you just a few of those examples where small rural towns recognized that although they had manageable obligations, that there were ways they could meet those obligations that didn't depend on having sewer and water service and some of the other infrastructure requirements that normally go with higher density development. There was one town, it's now 100% Highlands Municipality, it had an old farmer's home administration project for senior citizens, and that had been refinanced a couple of times, and they were no longer going to be able to get any kind of credit for it for the third round. Fortunately, the developer needed to refinance once again. The developer asked for an extension of the pilot that he had gotten originally, and we said, wait a minute, there's an opportunity here. And we agreed to the pilot in that town in exchange for 10 of the 50 units being COAH qualified units with deed restrictions for 30 years, including one very low income unit, which happened to have an existing tenant that had to remain there under the terms of the prior funding, so the developer was amenable to simply deed restricting that unit as a very low income unit. That was a creative way to get some deed-restricted affordable housing that would continue to qualify after the housing had stopped qualifying as affordable housing. Another small town, Harmony Township in Warren County, bought up some lots and had Habitat for Humanity build affordable housing on them, and also bought up some buildings that had 2- and 3-unit apartments, put deed restrictions on them, and then rented them out to low and moderate income households. Another town, Holland Township, had a very successful accessory apartment program going. Some of the apartments that came into the program were illegal accessory apartments, which were brought in and rehabilitated, and then the deed restrictions were placed on those units. In other cases, they were newly created accessory apartment units out of pre-existing agricultural buildings. So there were a number of examples, and they did 10 or 11 of those. So that was a lot for a rural community. Delaware Township had an inclusionary development where they had really attractive, very tightly built, affordable units right on the main drag in Surgeonsville, and then behind them a somewhat more suburban development of single-family homes. But nevertheless, the affordable units fit really well into the fabric of the community in terms of their architecture and their relationship to the sort of walkability of the little village there. Branchburg Township worked, and this was a second round approach, but they worked closely with Midland Schools, which had an entity called I don't know whether it was Midland Adult Services or Midland Residential Communities, where they were trying to locate group homes throughout the region in places where they could still administer those group homes and help people get to employment opportunities. They were able to subsidize the development of those group homes. At that point, what was the going rate for an RCA, but they used it locally to get Midland to build group homes and create group homes within their community, which was close to where the Midland School was located, so there would be ease of administration. So there are all of these different kinds of approaches that were permitted, or are still permitted in some cases by COAH's rules, where you're dealing with accessory apartments, alternative living arrangements, market to affordable programs, all opportunities that can be used to create on an ongoing basis affordable housing, particularly in communities where you're not going to get large-scale inclusionary developments because you haven't got the infrastructure. There are admittedly places throughout this state where large-scale inclusionary developments are appropriate, and I think more and more that is becoming places where you're having redevelopment because there is very little land left in this state that is open green fields, that is not heavily regulated by some agency or another, and that will still have access to public sewer and water infrastructure, because that is tightening down. Marty talked about the problems with getting the State Planning Commission and COAH on the same page. You know, I think New Jersey is a state with multiple personality disorder, and I think part of the problem is that you have a DEP that has deep roots in this state. Each of its little divisions and bureaus was basically created by separate legislation, so it was built from the ground up. It is impossible for somebody to take over DEP and say, yeah, we'll get on board with trying to arrange our environmental policies so they actually support the production of affordable housing. Unfortunately, the State Planning Commission was listening more to DEP than to COAH when it was coming up with various iterations of a state plan, and consequently, we don't have anything workable. I would say, though, that there is still reason for optimism, but I think that is fading away in the absence of leadership. Sure, you're still going to have hardcore towns, particularly, I think, in the core of older suburbs around the inner cities, where I think the race card, which is a valid issue, and I think is something that isn't talked about enough and has been brought up today, where I think the race card may be much more of an issue than people talk about. I think in the outer suburbs, it's sort of less of an immediate threat, and so, if there is some diversity in the housing that's created, people tend to welcome that because it isn't an overwhelming vision of becoming the town next door, and I think that's an issue. I think part of the problem in New Jersey, and one of the reasons you have resistance to affordable housing, is not the affordable housing, it's what comes with it. It's the higher densities of development, it's the traffic, it's the school impacts. And as long as we continue to use zoning, which is a tool that we allow towns to administer locally, to address the affordable housing problem, and don't also address the responsibilities on the state level, possibly through constitutional amendments, to deal with how we are funding education in the state, we are not going to do more than put a Band-Aid on the problem. That doesn't mean we should stop trying, and I think you've heard speakers talking about the accomplishments that have been made as a result of Mount Laurel 2 and COAH and the Fair Housing Act. I think that we need to continue to try, because I think anything is better than nothing, and the more you advance something forward, the less resistance I think you begin to feel. But I think we've lost some of the momentum that we need to then rebuild. So I scorn the current administration of the state of New Jersey for the lack of leadership. I think it has been a huge setback, and I am hoping that will change in the future.
Good morning. My name is Kevin Walsh. I'm an attorney and the Associate Director with Fair Share Housing Center, which is an organization that's been advocating for Mount Laurel since 1975. It was founded by some of the plaintiffs and attorneys involved in the original case. This is a panel about Mount Laurel, and despite some of the sort of pessimistic views that have been expressed, I want to tell you that I'm here this morning to celebrate because Chris Christie was just re-inaugurated, 2 days ago, right? And we survived 4 years of his first term with him not doing any lasting damage on the Mount Laurel doctrine. Sort of allow yourself, if you'd like, sort of an internal woo-hoo. Because 4 years ago, I think that many a political pundit, many a person thinking about this that understands these issues would not have thought that it was likely that we would have survived 4 years when he famously in Tom's River on the campaign trail declared that he was going to gut Mount Laurel. And then somebody sort of attacked him from the right and said, no, you got to gut it and then torture it or something. And we've gotten through 4 years of Christie, having done some very real damage, have no doubt. But it is not lasting damage, as the infrastructure remains, the legal principles remain the same. And some of the pieces of the implementation of Mount Laurel that led to the success you heard earlier remain in place. But there has been real damage. And some of that damage has played out in the delay with the third round rules, which isn't just the current governor. And we're facing in the next month, maybe the next couple of weeks, maybe today when I get back from the office, some really crucial next steps as the appellate division considers what to do with the fact that that COAH no doubt in part because of the administration, has done nothing to comply with the court's order to adopt regulations by the end of February. And there's, it's anyone's bet what will happen. But thus far, the courts have not indicated, although they may have taken longer than I would like, they have not indicated that they intend to back down on these issues. We've filed a motion to enforce litigants' rights, and I'm optimistic that will lead to something. Word coming out of the front office is that consultants have been hired, but there's no contracts anywhere. There's no, we filed open requests within DCA and COAH, so it's not clear who the consultants are or what it is that they are, what they've been hired to do, I guess. I don't think legislation is likely anytime soon. There was a bill on the governor's desk that was supported by the business community and by many housing advocates. The numbers on it were somewhat low in my organization's view, but it was something that had the underpinnings of a constitutional bill, and it was rejected by the governor. So I don't think that the legislature, as long as he's in office, is likely to do anything. But I think we are going to be moving on to a new phase in some fashion, in which, as a result of the Supreme Court's decision affirming the appellate division's decision in 2010, exclusionary zoning must still be checked. And although I agree with Jeff Serenian that there's many ways in which the legislature has been given greater discretion with how to act, the most important piece, I think, of the court's decision is that the legislature still must, if it's going to change the Fair Housing Act, perhaps it could just do away with the Fair Housing Act completely, but whatever it does, whatever comes next, in order to comply with Mount Laurel, it must recognize the reality that many suburban municipalities, when acting in their self-interest, which is what they're elected to do, most often, especially the wealthier ones, adopt zoning that, as we've heard today, is exclusionary. So whatever comes next, it may be a special master, maybe somebody here will be the special master. Could you raise your hand? Whatever happens next, it seems likely that that Mount Laurel will be enforced and that a check on exclusionary zoning will remain. There was some sort of suggestion that part of the reason for the delay is that something went wrong. And I take issue with that. I think that what went wrong was nothing. The problem was that COAH wasn't broken. And although there's a lot of things that I would have changed about COAH, and we've attempted to, and at times with some success, the fundamental problem and what led to the delay that we have right now, albeit continuing under the Christie administration, is really that Mount Laurel was working, that COAH was working in placing a check on municipalities. And you had all these problems started when you had two suburban mayors, Governor McGreevey, former mayor of Woodbridge, Susan Bass-Levin, commissioner of DCA, former mayor of Cherry Hill, both of whom were held accountable under Mount Laurel, didn't like it, and decided that they would attempt to do something about it, not because COAH was broken, not because COAH had in some way failed in its underlying mission, but that in some areas COAH worked well. And Cherry Hill, given its job base, is a place that should have a significant obligation, is a place that has been targeted for growth. And the prime movement at that point was intended to do away with that because it was working too well. The part of, I think, the development in the past decade is that Mount Laurel has developed a very real constituency. And you don't need to look to me to that. Look to the legislature, which in the face of, most recently in the face of a very powerful governor who many legislators are afraid to take on, honestly. They united the two houses, albeit along party lines, and passed half-decent housing legislation that many folks supported, including the business community, and that many housing advocates supported. There was clergy involved, there were civil rights groups involved. they're reaching out to their legislators. That strikes me as a sign of a constituency that the legislature responded to that sort of push. Same thing in 2008 with A500. RCAs were abolished because the Speaker of the General Assembly, Joe Roberts, called it blood money, said that it offended him, and that one of his great quotes was that we all need to move together, move forward together, not pay others to stay behind. And that again is, that is not a rogue legislative leader. That is a politically savvy person who, in my estimation, recognized the broad support both from civil rights groups, from clergy, and from others, who, although they don't always engage in this conversation in the way we are today, recognize that housing costs too much and expect something to be done about it. The nice thing out of all this, the one thing that we've sort of taken away out of all this, is that municipalities really aren't very well organized and you on these issues. And the reason they're not is because our 565 municipalities actually have very different stakes in this. Many of them have met their obligations, have political power, and want other municipalities to meet their obligations, because if they don't, they think that the ones that have are going to be the losers. And so you have two municipalities showing up in the third round case, Montclair and Pennsauken, which I think is reflective of the way many municipalities feel, saying that all municipalities have an obligation to do their fair share. And that if Mount Laurel becomes optional, if we lose the check on exclusionary zoning, if we lose the check on home rule, we're all going to be worse off. And that is something that I think, as we move to the next phase, should be considered more, and actually in the past has been. Most of the towns that have met their fair share, the urban aid municipalities, their voice needs to be more heard, better heard, because if it's not, they're going to continue to be the place that disproportionately house lower income households. One of the statements made was that we need attainable goals. And another one was from Jeff that we need to foster public acceptance. And I think, as Larry said, the notion that one pursues public acceptance at the cost of effective civil rights enforcement, I think is one that we need to reject in the public interest community right off. Because checking exclusionary zoning in a place where it's politically popular in some communities will simply make the doctrine ineffective. I think, if I were to amend what Jeff said there, I think what is often meant when people say we need public acceptance is that you actually need to placate suburban mayors who find it politically difficult to pursue compliance with the Mount Laurel doctrine, because doing their fair share of what the region actually requires is hard to justify politically. And that is exactly why the Supreme Court, when it recognized this, didn't interpret a statute. It interpreted the Constitution, because it realized that politically this will always be difficult. And if the goal is to get the numbers low to pursue political acceptance, I can say with absolute certainty that the next move will be a mayor who's running for the Assembly or Senate, who issues a press release stirring it up again, which says, that 50-unit obligation that I have to do, that's just too high. I shouldn't have to do more than a 10-unit obligation, because in some quarters, bashing Mount Laurel is politically popular. In many, it's not, and it doesn't occur there, but the notion that we should get the numbers low is a losing battle in which we'll always be aiming lower and lower. I think where we're headed and what's exciting is that we have survived 4 years. We're headed to a place in which I'm optimistic that the courts will do something. And although we've had a 14-year delay, and Governor Christie only gets credit, I guess, for 4 of those years, we have a legislature thus far that is either going to be inactive, which is the current sign, or, to the extent that we've seen recent efforts, is going to continue the check on home rule, because I think the legislature, too, is convinced that too many wealthier suburban municipalities, if given the chance, won't do their fair share. Thanks.
Terrific. Obviously, Kevin's remarks, particularly those in response to Jeffrey's, would suggest an opportunity for Jeffrey to respond, but unfortunately, this is not a law school classroom. I cannot let that happen because that would ignore the many of you who, in the remaining 15 minutes, I'm sure, have questions. So maybe we'll get back to that. I'm sure Jeffrey does have something to say about that, but it'd be nice to hear you all. We don't appear to have roving mics, but the room's not large, so if you stand with your question, I'm sure we can hear you. Questions? Really? Please. Yes.
Is it just sheer naivete to think that you could take mayors and councilmen, councilwomen on a fact-finding bus tour within their region to see actual affordable housing developments and how they're working? Is it impossible to change attitudes? I think that so many very attractive developments that work have been put together using the tax credit program or rehabbing old Section 8s into mixed income developments. Isn't there a way that instead of focusing the research on the benefits that affordable housing has had for low-income housing, to also show research on how these properties work well within their communities? As one of the speakers commented on, that the Edward Lawrence homes work very well within the do it visually, take people on a bus tour. There must be some people that can be persuaded.
Who wants it, that one? Yeah.
I'd like to respond to that. You need to understand that there's hundreds of municipalities that have complied, and there's many affordable housing projects throughout the state. So it's not as if public officials aren't aware that there's affordable housing projects and that they work well. And there's also examples that there are affordable housing projects that are towns look at and say, I would never want that in my town. And with a driving factor in the public's reaction, in my experience, is density. You know, how intensively are these parcels developed? You know, parcels that are developed at a lower intensity, you know, tend to not be, are fine. But it's when you see projects that are really just, they packed in every last square inch, you know, that's the kind of thing that towns look at and say, you know, I don't want that here.
Yeah.
Just to add on to that, and here I'm just giving voice to some of the COAH directors I interviewed and also staff, so this is a narrow perspective to the agency. But some of them raised the question to me, or a concern about why is it that COAH developed the way it did, and that it kind of degenerated into a almost total preoccupation with numbers, and that if COAH, if we were to do COAH over again, COAH should be involved with more affirmative marketing, design, innovations, financial assistance, working closely with the NJHMFA, and a much more comprehensive picture to affordable housing and the way affordable housing fits within smart growth and sustainable communities. But somehow that didn't happen. Maybe because of the nature, the inherent nature of state bureaucracy, maybe because of the political pressures on the agency. But a more expansive view of the agency might have addressed some of these issues up front.
Kevin.
I think that, is this on? It is. I think that the question about showing people examples, the Housing and Community Development Network of New Jersey has done that, linking up nonprofits with mayors and others and given tours. And, I think it was well received. I think that part of the difficulty is that elected officials, given the nature of our democracy and their time and other issues, they turn over. And so you sort of do need an ongoing education for that, and there's lots of good examples out there of places that work and some that don't work well to show. But there's, for every one of those that work well, there's an example where there's a group of neighbors that show up and oppose it, and the unfortunate reality is that controversy gets better coverage than things that work well. And so a lot of the narrative that is developed is that affordable housing is politically unpopular, which it is in some communities. And so that I think is the dynamic you're pushing against, is even the best intentioned mayors want to get reelected most often. There's one mayor in particular who I've seen speak on this, the mayor of West Hampton, New Jersey, Carolyn Chang. And what she does is sits down, and she has a very close story that involves growing up in affordable housing, and she invites her constituents to talk with her, and she has barbecues and things like that when these issues are going to be addressed. And I think that's a good, responsible example of mayors who are in places that have the room for growth, but and address some of the biases and prejudices responsibly. And I think that may be a more effective approach than educating the mayors. Although that's still needed, I think what's needed most is to change some of the hearts and minds of people who are fighting this really with little knowledge about what actually happens. And to Jeff's point about density, my wife is from Irvine, California. I just got back from there late last night, delayed because of the weather. And go to Southern California if you want good examples of where density works. I mean, I know I'm preaching to the choir on this one, but some of the most valuable, best planned places in the whole country I was just driving through over the last couple days. And it's a beautiful place. The notion that density is somehow bad is so wrong-headed, but that's really where people, I think planners, need to educate their clients better on the municipal side, because it is, some of the most valuable land in New Jersey is in communities. Think about Princeton and Haddonfield and Morristown, where they've embraced density and they've turned it around to their advantage. And so that's really something, historically anyway, that's really something that I think if we're going to take mayors on tours, we should tour them around to places with density that works well.
Sure.
Bob Basic, Director of Planning for Somerset County. I just want to clear up one misconception that was conveyed, and that is that exclusionary zoning is alive and well in Somerset and Monmouth County because of the HOS study that was quoted. The fact of the matter is that study did not take into account existing parcel-based zoning. They didn't take into account the certified plans that have been filed in both counties. They didn't take into account the approved projects. They didn't take into account the environmental constraints analysis that was done by both counties through the WIMP process. Our build-out numbers don't match those numbers by any calculation. And also, if you get to track what's happening with zoning over the years, we have pictures from 70, 80, 90, 2000. You can see the changing landscape, in terms of higher density development that has occurred, mixed-use development, redevelopment projects. There's a complete dynamics that is occurring. We just completed a cutting-edge study on repositioning commercial sites in Somerset County, where we worked with pilot municipalities. In every case, we presented their zoning, which was exclusively commercial, to various scenarios. Every municipality chose the smart growth scenario, which incorporated income balanced housing, mixed use, because they realized the changing dynamics that are occurring in the marketplace. So I think as we begin to introduce those kind of discussions with our municipalities instead of just plain old numbers, it changes really the dynamics.
I'd also just, if I could comment, and I think it relates to the comments for the last couple of comments. One of the reasons that we made some progress after Mount Laurel 2 and with the establishment of COAH is in part because there was both a stick out there, which was that you're going to get sued by a developer if you didn't do something, and there was also the carrot once the Fair Housing Act was adopted of coming in voluntarily and with for COAH compliance and being able to control your own destiny. And I think that one of the things that's happened is that we don't have a stick as far as third round obligations are concerned right now. We don't have the carrot of any benefit to filing something with COAH because they're not going to do anything with it and they're not going to tell you whether you're okay. So we've sort of lost that, and it's one of the reasons we're at sea. But I do agree that all of those good intentions that started to develop are still there and I think can be harnessed. And I also think that one of the things that we know from how well the prior rounds worked is that if you give a politician a number that he has to deal with, he'll find a way to spin it to his advantage. So I don't think have to convince mayors and other politicians in communities that affordable housing is a good thing. They'll probably never really accept that. But if you can convince them that it's in the interests of their community to develop a compliant housing plan and proceed with implementing it because it's better than any alternative that's out there, you'll make progress. And attitudes will change as people see the results of that. I think in many communities where there was staunch resistance to a builder's remedy and then the project was ultimately built, that it's sort of like, oh, it's not so bad, and I think that there's been gradually more acceptance. But that acceptance is going to come only with continuing progress and with letting people know that there are design alternatives, as Bob Biesick has said, that can make affordable housing pretty acceptable.
I think we have time for one more question. Wow. Craig.
I'll take it. The one constant we've had for the last 30 or 40 years is the issues of race and class in relationship with city to suburb. The one thing that's changed in each decade is the demographic challenge that we're facing as a state relative to who we're providing the market rate housing for. In the early days, we were fighting for 3-story walk-up flats in the 80s. In the 90s, it was small lot singles. I think as all the planners are dealing with smart growth and TODs and looking forward, the solutions that we're trying to locate in the suburbs now are higher rise, higher density buildings, mixed use kinds of developments, things that are radically different than we've done in the past, and a challenge to suburban areas. I'd love if the panelists would address, as we go forward, since the problem we're now solving is a different one demographically and economically, if that factors into the way you approach this overall issue.
That's a great question.
I'll try to tackle that briefly, but I think I'd like to hear from people on either side of me on this particular issue. I think that you're right, that certainly for the large-scale inclusionary developments, you are getting a model that's much higher density than is in COAH's regulations and that most municipalities, suburban municipalities ever contemplated. I think that the only way to sell that is by the fact that the towns recognize that they have limited areas in which they have access to sewer and water now. I think that is the DEP is, with the way they're going with the wastewater management rules, is really going to be cutting back on all those sewer service areas. So it seems to me that there is an efficiency to taking a site and developing it intensely. In Lebanon Borough, they developed a site that happened to be right along the Route 78 corridor, so it was going to have some major non-residential development. If it didn't have residential development, it was the result of a builder's remedy lawsuit, but it has developed and it's worked and nobody minds it. It's not the horrible thing everybody thought it was going to be. And I think more of those examples simply have to happen before towns begin to accept that this is not a terrible way to do affordable housing where you have the infrastructure to support that.
Alan?
I think the larger point is that we are looking at some major demographic shifts. We're looking at some major changes in housing preference. Not happening a great deal in New Jersey, but if you look at places like Pittsburgh, St. Louis, Cincinnati, you're seeing a younger generation flocking back to the cities, looking for higher density development, mixed use, life, excitement, and so forth. And I think that is one of the major trends that cities, townships, boroughs should start looking at in terms of keeping relevant in the future. No form of housing, no model of suburban development or so forth is guaranteed to be successful forever. And I think there's a real question as to whether some of our exurban developments on 3-acre lots with these huge houses are going to remain as successful from a market standpoint in the future as they have been in the recent past. So I think the whole question of rethinking what kind of building types we're doing, looking at densification in appropriate locations, especially where you have transit, where you have major arteries, where you have sewer and water, I think is a really important thing. And it goes back to the point is that if we are going to deal with affordable housing effectively going forward, we really have to integrate it much more into overall planning of communities than we have in the past.
Yeah, I think, the one observation in recent events, I think, point up this, is that the bigger the developments and the higher, that have higher density, most often in my experience, are the ones that are most politically wired. And so they overcome home rule by sort of going to regional politics machines that exist so in some ways very often above the mayors or alongside the mayors. And so those are places where I think home rule is is very often not quite as tangible as it is given the money interests and stakes and the way in which they're politically wired. And what was interesting is all throughout the growth share fight, the administration's position was let municipalities make their own decisions. I understand while I was away in California, there's some revelations that it's let them make their own decisions usually. And I think that sort of shows, in some ways, the way some of these bigger developments happen is that they are big politics.
I just, if I may, I just want to follow up with Alan's answer because you repeated something in it that you said earlier. You said that affordable housing needed to be more integrated into local planning, but you also said that we need a distinction between fair share goals and housing needs. And in light of what the court has said in reiterating the notion of general welfare as measured by regional housing need, there would appear to be something of a contradiction there that needs to be squared.
Well, the basic point I wanted to make is that meeting housing needs is a far broader issue than simply building new affordable housing and through the land use process. And what the Mount Laurel decision was about, it said you may not use your land use process to exclude, you have to integrate, you have to use it to incorporate affordable housing in the development going forward. But so that's important, but that's only one part of affordable housing need. We know that about 80% of the people with housing deficiencies in New Jersey have housing deficiencies not because they live in housing that is physically too small or too inadequate, but because they are paying outrageous amounts of their income for the housing they live in. Now, that is a problem that is not necessarily solved by creating additional housing. It's not a question of housing supply. It's a question of housing finance, of housing affordability. So what I was saying is that if we're going to be serious about meeting housing needs, we need to have a comprehensive strategy that deals with affordability, that deals with crowding, that deals with supply, as well as maintaining the quality of the existing stock. The land use process can only deal with one part of that. And I think we have to be realistic about segmenting out that part of housing needs that can be addressed realistically through the land use process and how we're going to deal with other housing needs, whether it's through, vouchers, rent supplements, rehab, or other means, in order to actually address the housing needs of people as distinct from abstractions.
Thank you. Well, as much as I'm sure we'd like to go on, because there's so much, I remind you that we have another panel this afternoon, which will, in some respects, take up where this one left off and look more specifically at COAH, its options in the future. But I'm sure your growling tummies tell you it's time to eat. Before you go, I want to thank this esteemed panel for a terrific job. Thank you all for coming out today. And thank you all.
One last administrative thing for the lawyers. I have the certificate that you need. Of course I did. I will trade you. Fill out